Lord's permission, it's an emergency situation that I'm
Circulate an email. I'll attend to it.
grateful.
Entry submissions also.
Yes, Malay, I just sent some.
But Mr.
supplements.
Sibal, we have to freeze submissions at some point because it creates such a problem for us when we have to start, putting things together for the judgment.
I understand that, Malay, what happened in our conversations and the dialogue the other day, Malay. I just wanted to clarify some issues. That's why, otherwise, Malay,
Even the problem has been in the last constitution bench also, I found. Thousands of pages were dumped almost on the last second day. It becomes
Lordship is right.
impossible
It's a
to
problem.
formulate, we have to formulate a judgment. If we don't know where
No, your lordship
starting,
is-
where a person is
I'm
going.
not saying no,
How
Malay.
will
The
it,
problem is
rise?
sometimes, Malay, when the formulations happen at the beginning of a hearing, Malay, as the hearing proceeds, Malay, there are nuances that need to be addressed. That's all, Malay, not for any other reason. I appreciate what my lord is saying. I'm sorry for that.
Supplementary submission. Appeal, sir.
You and the supplementary submissions, Malay, if your lordship be kind enough to turn to that. And I invite my lord's attention to page 70. Yes, sorry. I've sent it.
Send again.
I'm sorry, Malay. Lordship has it?
870 PDF
To Mr. Sibal?
Malay, it is combined with the earlier submissions, Malay.
So now
That's
these
it.
are now the updated submissions.
That's right. So, Malay,
So
it's
we
combined
don't
with
look at the earlier
There is no other. It's a running page now, Malay.
Our concern is this: if we allow these submissions, each one of the other council on your side and on the other side will do this, give us. So at the end of it, we will have about 15 or 16 additional submissions. And I can just tell you, we were just discussing, and this is not a secret. When it comes to writing a judgment, for instance, we are in the midst of, now seeing what to decide in the same-sex marriage equality which was argued. with the additional submissions in rejoinder, sir rejoinder, when you actually sit down to open a matter for judgment, it becomes just impossible for so many, for us to.
No doubt about it.
Principal, we had clearly put it down that we will not accept submissions beyond a particular date. It will be violation of Article 14 if we permit you to do it and not permit the others to.
All right, Manoj, I'll make oral submissions on that.
We have marked those submissions. See, the problem is we've also marked those submissions which we made
I
earlier.
appreciate.
Now consolidation. Let us go by that submission which was earlier.
But most of them would be an elaboration of what you have argued. You can
No,
tell
but
us
for
orally
example,
what
like-
those nuances we
I
can
did
tell.
not
We've been
place-
taking notes where we have put questions. We have come up with some answers. We've also been taking notes.
Let me, Malaj, not waste your lordship's time on it. Malaj, look, I'm telling your lordships what has happened. Number one, Malaj, there are some speeches made in the J&K Constituent Assembly which were not part of the original. So I wanted to just cite those, Malaj. That's part of it.
No, but even those, now have to be part of the documents compilation which is frozen, which so much of research by
It's there.
20 lawyers, I'm
It's
sure
there,
nobody would
it's
have
there,
missed those.
it's there, Malaj. It's there, it's in the document.
But then refer to it in the documents, no difficulty.
I
Well, the record is frozen as when we began the
Or
hearing.
very well, very
For
well.
synopsis and for
The
record.
documents you can show us certainly no
Very
difficulty.
well, doesn't matter. I'll show the
Yes.
document.
Whatever they are.
Whatever documents
Yeah,
on the
no
record, there's
no
no
problem,
difficulty.
because
We'll
I
see
show-
those.
I'll show.
Somebody would have filed them.
Yes, we filed them, Malaj. Volume 8, Malaj.
Yes.
Yeah. That, with what is it? Volume 7. PDF page 102, volume 7. Malaj. But where is the speech? Whose speech? The relevant page we'll have to see, no? Documents. PDF page 101. This is Sheikh Abdullah's speech, Malaj, which is part of the documents, Malaj. I just wanted to,
Volume 7,
Volume
page
7.
136, that's volume 7, page 1.
volume 7, yes, but the relevant part of Sheikh Abdullah's speech is at page 101. PDF 101.
101.
Yes. In the submissions, I just put those paragraphs so that it doesn't waste time. But anyway, Malaj, I'll refer to that. It's not in addition to anything.
That's 1460.
1460, that's absolutely right.
What is the date of the speech of Sheikh Abdullah?
I just give that to you, Lordship.
This is
5th
in the
November,
in the
1951.
Constituent Assembly, the J&K
1951,
Constituent Assembly.
Yes, 5th November 1951. I'm not editing anything new, Malaj. I just, because I didn't want your Lordship's time to be wasted, so I only pointed those paragraphs. There's nothing new in these submissions. That's all. If I
The
may
agony
read,
of
Malaj.
this change, the agony of this change.
Yes, the agony of this changeover became all the more intense as a result of the position in which the Indian states were left under the Indian Independence Act of the British Parliament. The paramountcy of British Crown, against which the princes had been leaning it should be, lapsed, and it was made clear that it would not be transferred to either of the succeeding dominions. There were three alternative courses open to them. They could accede to either of the two dominions or remain independent. This gave the prince himself the option to decide the fate of their states. Following the announcement of Mountbatten Plan on June 3, some of the Indian states acceded to Pakistan and some to India by means of instruments of accession executed through their princes. There were also some who entered into standstill agreements with either or both pending finalization of their decisions. The betrayal of the interests of the state's people had been expected following the rejections of the memorandum of the National Conference, and we in Kashmir decided to place the issue before the people themselves. This is how our well-known Quit Kashmir agitation began. The National Conference once led the people through a great struggle, and once again the ruler tried to curb it, this time with unprecedented severity. But when the whole people is one and the move and they move and the move it is not possible to repress them, and they do not stop until they wrest freedom and justice for themselves from the unwilling hands of those about them. The crucial date of India and Pakistan independence therefore came when I and my colleagues were still behind prison bars. The whole subcontinent was in a state of high tension and disturbance. If at that time the head of the state of Jammu Kashmir had even the slightest sense of realism or a proper awareness of the danger lurking in the situation, he would have immediately taken the people into confidence. By associating their representatives with administration, I am sure many of the compilations that complications it should be that arose later could have been avoided. Instead of that, the Maharaja government entered into a standstill agreement with Pakistan, and this was accepted without question by that dominion. Now, the next is important. A similar arrangement was suggested to India also, but it is noteworthy that the government of India insisted that it could not consider any agreement entered into by the government of the state valid until it had approval of the people's representatives. While the leaders consistently refused to recognize the vital issue of accession without first securing the approval of his people, the Muslim League and Pakistan government supported the claims of the rulers to speak for their state. The late Mr. Jinnah took the position that after lapse of paramountcy, the princes were completely independent and that they could themselves determine what relations they should have with the two dominions. Throughout the struggles that the people of Kashmir waged against autocracy, we should never forget that the Muslim League leadership had completely dissociated itself from them, and that during the upsurge in 1946, their local party organs had assisted the administration to suppress the movement. At this crucial time, when Pakistan was under the cover of secrecy, perfecting its own plans, and the Dawn, the Muslim League official organ in Karachi, was appearing to the Maharaja to accede to Pakistan on the grounds that he would have great freedom there in India. It was at this stage, taking advantage of the isolation of the Kashmiris from the rest of the world, that Pakistan imposed an economic blockade upon us with a view to starving us to submission. Attempts were made even to excite communal hatred, to disrupt our peaceful civic life. Even in the face of such provocations, the National Conference, I'm proud to say, took an objective and democratic stand. Instead, immediately on my release from imprisonment, I clarified the issue of a mass meeting in Srinagar. The first and fundamental issue before us was the establishment of a popular government. Our objective might be summarized: freedom first, then alone could free people decide the future association through accession. I also made it clear that the National Conference would consider this issue without prejudice to political friends. So leave that around, Mullahs. Then Mullahs, kindly come to the paragraph. The overwhelming pressure of this invasion brought about a total collapse of the armed forces of the state, as well as its administrative machinery, leaving the completely defenseless people at the mercy of invaders. It was not an ordinary type of invasion, inasmuch as no canons of warfare were observed. The tribesmen who attacked the state in thousands killed, burned, looted, and destroyed whatever came in their way. And in this savagery, no section of the people could escape. Even the nuns and nurses of the Catholic missions were killed or brutally maltreated. As these raiders advanced towards Srinagar, the last vestige of authority, which lay in the person of the Maharaja, suddenly disappeared from the capital. This created a strange vacuum and would have certainly led the occupation of the whole state by Pakistan troops and tribesmen if at this supreme hour of crisis, the entire people of Kashmir had not risen like the solid barrier against the aggressor. They halted this onrush, but could not stop it entirely, as the defenders had not enough experience, training. This is the background on the basis of which the accession took place. Then let us kindly come to this paragraph. When the raiders, 1463, were last approaching Srinagar, we could think of only one way to save the state from total annihilation: by asking for help from a friendly neighbor. The representative of the National Conference therefore flew to Delhi to seek help from the government of India, but the absence of any constitutionalities between our state of India made it impossible for her to render us any effective assistance in meeting the aggressor. As I said earlier, India had refused to sign a standstill agreement with the state from the ground that he could not accept it. Accept such an agreement until it had the approval of the people. But now, since the people's representatives themselves sought an alliance, the government of India showed readiness to accept it. Legally, the instrument of accession had to be signed by the ruler of the state. This the Maharaja did. While accepting that accession, the government of India said that she wished that as soon as law and order has been restored in Kashmir and our soil cleared of invader, the question of the state succession should be settled by reference of the people. Actuated by sincere desire to avoid bloodshed and further conflict, the government of India approached the Security Council in 1948 with a plan against Pakistan. The request was simple. The contention of India was that Pakistan was responsible for the invasion of Kashmir and was continuing to help the raiders who had been employed as mercenaries. And it was further said that legally bound as India was to clear the Jammu and Kashmir state of raiders, might be constrained to pursue the invaders to their bases in Pakistan, which might lead to still bigger conflagration. India therefore wanted the Security Council to dispose of the case as quickly as possible in the interest of justice. That's how the question of plebiscite mullahs came before the Security Council. Then Muller's paragraph, this is the essential background which we must fully take into account. Now I shall indicate some of the considerations which should be kept in view when you, the honorable members of the August Assembly, shoulder the grave responsibility of giving our considered opinion on this issue of accession, which affects not only the present generation of our people, but generations yet to come. Muller's now skip the following paragraphs and then come to Muller's, the real character. Muller's kindly come to paragraph. As a realist, Muller, that paragraph. As a realist, I'm conscious that nothing is all black and is all black or all white, that there are many facts to each of the propositions before us. I shall first speak on the merits and demerits of the state succession to India. In the final analysis, as I understand it, it is the kinship of ideals which determines the strength of ties between two states. The National Congress has consistently supported the cause of the state's people's freedom. The autocratic rule of princes has been away with and representative government have been entrusted with the administration. Steps towards democratization have been taken, and these have raised the people's standard of living, brought about much needed social reconstruction, and above all, built up their very independence of spirit. Naturally, if we accede to India, there is no danger of a revival of feudalism and autocracy. Moreover, during the last 4 years, the government of India has never tried to interfere in our internal economy. The experience has strengthened our confidence in them as a democratic state. The real character of a state is revealed in its constitution. The Indian constitution has set before us the country, the goal of secular democracy. Well, as we may leave that out, and then leave the other things out. Then PDF 562. Speeches.
Principal, they accept whatever.
No. Yeah, while the state.
Yes.
Is on 11th August 1952, soon after the Delhi Agreement in July 1952. And whereas in PDF 562 at 1921, he then explains why the provision is temporal. Here I would like to point out, my lords have that paragraph?
Page?
Page 1921, PDF 562.
But after that, actually, we were reading at it goes on to about 1466, where he specifically speaks about the importance of the affiliation with India and accession to India, because he speaks in terms of, first he speaks about the Indian Constitution.
That's correct.
Second, it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking
That's
place
correct.
post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to
Absolutely.
an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse.
That's correct.
For us to carry on trade through the auspices of India. And this really continues until PDF page 107.
I didn't want to refer to it because it would take too long. Two, it's the background, but we're dealing with the temporary provision. That's why I didn't refer to it. But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution, just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you'll have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being
secular...
Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is, of course, only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. Chief is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the executive act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in
Man with great
1951 when he was
Man with
speaking
great
about the importance of economic interest, which is what the world is talking about today
Absolutely.
in a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. So, Manoj, the point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1). And the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, Mullahs, are implemented. That's the question. That's the... You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, Mullahs, of the Constituent Assembly as legislative assembly through an executive act. Just then I'll come straight away to the issue, Mullahs, 1921.
1921.
Yes, PDF, Mullahs. 562.
Yes, volume? Which volume is this, Mr. Sibu?
Same volume, Malad, same volume.
Volume 7.
Yes, same, Malad, the same speech, Malad. Comes a little later.
19.
Sorry, same speaker comes a little later, Malad. 11th August is the speech. Yeah.
192. PDF page 562.
562, PDF 562. Sentence starting, Malad, paragraph starting here, I would like to point out. My lords have that?
Yes, see some problem.
That's correct. That's correct. That's correct.
Yes.
All my lords have it. I'll read it. Here, I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how Mallad's Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then let us kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952. And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. Whereas PDF 648, page 2007. This speech was given by Mir Qasim on 10th of November 1952. And the statement of the Sheikh Mullah, that discussion on his statement continues. Whereas in the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our eternal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why Mullah 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which is the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then let us kindly come to Mullah's, the social system which will be set up according to the program in New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis, or Dogras. Now, Mullahs, let's skip the rest. PDF page 694 now, Mullahs.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
The principle is, Mullahs, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central.
Cannot alter unilaterally
Yes.
the provisions of the Constitution
Of India as applicable to the Jammu and Kashmir. Including getting rid of the special status given, acceded to by the Union, by the Government of India, and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done. But
Yes.
that is the parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the constitution as it was applicable to the state of Jammu and Kashmir? That's the central question that your lordships will have to decide. Could Parliament, could the Union of India have done it?
So is it your case that the parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. Ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Well, your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Sibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions,
Agree?
right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
Yeah.
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
There's no
either
question.
you do it,
So you
either
cannot-
you do it. Well,
You cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But
That's
therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Milad. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Milad, let me see. That's a much higher level, Milad, to which I'm not, in fact, arguing that today. Milad, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
You understand?
It may not be permanent. It may be permanent. It may not be. You may change it. You may. You may
I
have.
said in the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done.
That's right.
Is flawed accordingly.
It's absolute. It's a fraud on the Constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They're not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really, at the moment, not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
Yes.
independent of the Council of Ministers. Step
36,
two,
38,
right.
and
Step
90.
two, right. Step two, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
yes,
3, the proclamation is issued under Article 356.
yes,
You said that the object of the proclamation under 356 to eventually restore democracy
that's right,
and not the decimation of democracy.
right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's
So
also an executive act.
all these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's
I
right.
think.
Absolutely. I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You've made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process
Well,
in
the
1957?
Constitution was adopted in 1957
Yes.
by the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves and said, we don't want, there's no need for this constitution. We want to be a state, the part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the three options that Sheikh Abdullah spoke about, namely either of joining Pakistan,
Yes.
acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relationship.
That still begs one question
Yeah.
as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Put 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself
No.
to
for
convert the
reason-
character of
Well,
370?
all right, Manas, now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Manas. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Manas, that it is
Or
not.
was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Manas, that it is amendable for the sake of argument. Then, Manas, how is to be amended? The Constitution must provide a solution, no, Manas? I'll assume, Manas, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, Then equally, 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Mullah, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Mullah, we have to find the modality within the constitution, not outside it, not vested in an executive power of the union. That cannot be. So if your lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370 bracket 3 itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests Mullah in the state. So if you say, Mullah, that C70 sub-article 3 provides that solution, but that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal,
Maybe
no, when you argue, then we'll have to take one. 360 is the power to amend the constitution. That's certainly there.
Yeah.
Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the constitution.
But your lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368.
Yeah.
370.
Including 370.
Yeah.
Then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional
This is
power.
not action under 368. Your lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the
that
court
power?
the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368, you can do it under 368?
So 368 is the power to amend the constitution.
But we are not, are we concerned with that here? I'm sorry, Manoj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Manoj,
You have the power within 370 to abrogate.
But Manoj, in that independent avenue must conform to the provisions of the Constitution. Whether an independent avenue derogates the provisions of the Constitution is no avenue at all.
Mr. Sibal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370. If
No.
we forget about the
Sorry.
proviso.
I'm sorry to say that, Manoj. I'm really
Just
sorry.
read three-
There is a
just read it
proviso.
once again. Just read
You
it
can't
once again.
exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the
That-
proviso,
the Clause 370 comes into play on the recommendation of the Constituent Assembly. Your lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the president will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will the proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. Well, you'll have to interpret it on its plain terms, Malat, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's at the heart of federalism, is this, Malat. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way, Malat. And Malat, 373 power has been exercised by the Constituent Assembly, saying no recommendation. And I'll come to your lordships, a judgment of Sampath Prakash Maharaj, which actually deals with this issue. So let's be clear, Maharaj. Sorry.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the. It only says that it only exercises the three choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. So out of three, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let's go back. Let's go back, Maharaj, to 1950, 26th of January. Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? There was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Malas. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. It was not temporary because this provision had to go. No. And therefore, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were ever confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role at that point in time. And the government of India in 1950, the Parliament, recognized that it is the Constituent Assembly on the recommendation of which 370 will be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, Maharaj, if 370 had been abrogated. It would be yet another state of India.
Mr. Sibal, you've made your point now. I think basically as we see it, your argument is in three layers. We looked at the background, the history. We look at 370 in the background, the constitutional history, the other history which we saw pre-independence. We interpret 370 therefore in the context of that history, and then we've gone to the modalities which were followed for abrogation, which you have said is unconstitutional. Now, after having explored this terrain,
Let's
which is
go
the next, how do we now progress?
Come back to the list of dates, Maharaj.
Right.
Well, with your 2 minutes I'll take. There is a speech by Muzaffar, M.A. Beg, Afzal Beg. Just it'll take only.
Just give us this the page and the gist of it. You can tell us.
It's 694, PDF 694. It's only temporariness of the article. That's why that's the last person.
All.
You need not go through it. It refers to the temporary nature of the
It
article.
would be in the same vein as Mir Qasim's speech at 6:48.
And Mullahs, kindly note this, he was a representative of Jammu and Kashmir in India's Constituent Assembly. There were 3 members total, he was one of them. So he was part of the Constituent Assembly of India as well. I said that a good deal of criticism was leveled in both houses of Parliament of India and in the outside press in regard to the intention of 370, that it is a temporary article and the special position of Kashmir ipso facto is of temporary nature. This raised doubts and suspicions not only in the minds of the people of the state, but also in the minds of our colleagues sitting in this house about our relationship with India and Kashmir had peculiar position in 1947. It has now. That peculiar position is a permanent character of the state. It would be unfair to say that this position is a temporary nature. Statements have been made that in due course of time, 370 will cease to exist and Kashmir is bound to become a Part B state. Expressions like these have in fact given rise to amendments proposed by honorable members to the statements of the Leader of the House. Some of these amendments are critical and some are unfriendly. And then he goes on to say that we did not even know that there was a note, a marginal note in this regard. This has just come up suddenly. We didn't know that there was a margin. Nobody told us that there'd be a marginal note. So anyway, that's all that he says. I just wanted to invite my Lord's attention to it. So in my supplementary submissions, only I have set out these passages, nothing more than that. And so last try, so long as it is not completed, Article 370 will remain there. And when it reaches completion, we shall give to Paul what Paul's and what gives to Peter what Peter's. This is the center. That is, center will have the exceeded subject and the rest will remain here. 370 will have to be accordingly altered. It would not mean that Kashmir state will cease to have its special position. Amending 370 may be necessary at the time when we finalize our constitution. But even then, legally, constitution as it cannot in any way rob Kashmir of its special privileges and position given to it by common agreement. 370 is therefore temporary till we complete our constitution. That's the spirit with which it was incorporated in the Constitution of India. This is the point, Madam. Anyway, Madam, so that's what I've done with this. Now
Yes.
kindly come back to the list of dates.
The list of dates are in.
Yes, we were at serial 71 in written submissions, compilation volume 2, PDF 53.
Volume.
Which begins with serial number 72.
Yes, serial number 72. Let's read 71, 3rd of August.
Yes.
The governor of the state of Jammu and Kashmir, my lord,
PDF, Mr. Subul, PDF?
PDF, my lord, 53, page 53 also.
Yes.
I'm sorry. Justice Call, my lord, has it?
Yes, that's why I said serial number 72, 5th August.
71, my
2009.
lord, I just want to read 71 also.
71.
The governor of the state of Jammu and Kashmir gave a press statement on the night of 3rd of August that he was not aware of any proposal to amend 370 or Article 35A, and that all security arrangements and reinforcements of the state were being made pursuant to intelligence inputs forecasting a major terror incident. On the 5th of August at 11 a.m., on August 5, the President issued the impugned order titled the Constitution Application to Jammu and Kashmir Order 2019. This is CO 272. Well, let's therefore mark, it's an executive act. The said order issued under Article 371 with the purported concurrence of the government of the state of Jammu and Kashmir inserted Article 367(4) of the Constitution of India. So that's what CO 20272 did. In particular, the newly inserted Article 367(4)(c) stated that references in the Constitution to the government of the state of Jammu and Kashmir would be construed as including references to the governor of Jammu and Kashmir. Further, 367(4)(d) amended subclause 3 of Article 370 by replacing the expression Constituent Assembly of the State with the Legislative Assembly of the State. Executive Act. Now, let's come and look at that. It's in volume 3, PDF page 101. That's right.
Volume 3 of what?
3
Documents.
of documents.
Document.
Yes,
Page 101.
101. Running page 494. Okay. Now kindly note, Malat, at this point in time, 356 was in operation.
Volume, Mr. Sibul, volume?
Volume 3, documents, volume 3, PDF
Documents
page
compilation. Documents compilation.
101. Note, Malat, at this time, 356 was in operation.
This is 5th August 2019 notification.
That's right. In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36, and 38, Governor could only act on the aid and advice of the Council of Ministers. That's the Jammu Kashmir Constitution. The governor could not represent the state. So the very inception of this executive order is constitutionally flawed. In exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the government of the state of Jammu and Kashmir, is placed to make the following order. This order may be called the Constitution Application to Jammu and Kashmir Order of 2019. It shall come into force at once and shall thereupon supersede the Constitution Application to Jammu and Kashmir Order 1954, because all amendments thereafter were to the 54 order, as amended from time to time. All the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So, to Article 367 shall be added the following clause. 4. For the purposes of this Constitution as it applies in relation to the state of Jammu and Kashmir, reference to this Constitution or to the provisions thereof shall be construed as reference to the Constitution or the provisions thereof as applicable or as applied in relation to the state. Reference to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth. And assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. D is even more serious. I don't think in any constitutional democracy in the world this has happened. In the famous Miller case in the UK, Manoj, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, Manoj, matter came to the Supreme Court. All the justices of the court said, "No, Manoj, your Lordship knows this is the executive power of the government, that they can prorogue the House." But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor, which he does not have. You assume to yourself under 350 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. C67.
just assist us, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place. For their constitutional design of ultimately abrogating 370, why was this amendment to 367 necessary?
Because, Malas, they themselves gave the power of the Legislative Assembly, which they were exercising in 356 as the Constituent Assembly, and recommended. Malas, they were ad
Normally
item with
when
my
a-
interpretation.
Yes,
They were ad item with my interpretation.
right.
That you needed the recommendation of the Constituent Assembly. So
They
how do you
constitu-
reach there?
They constituted the Legislative Assembly as the Constituent Assembly.
That's, and Malas, what they do is they don't interpret it. They say in Proviso 3 of 370, the expression Constituent Assembly of the state referred to in clause 3 shall read as Legislative Assembly. So they have amended Article 370 of the Constitution. Shall
Actually,
read as.
367 amendment was not required because you're exercising
Was.
power under clause 1 to say article.
No, it was required because you needed the recommendation of the Constituent
No,
Assembly.
no, that's something separate. But in 367, introducing clause 4, in terms of the notification dated 5th August 2019,
You required it because, Malas, they changed the definition of Constituent Assembly in 370 as Legislative Assembly. This is why they could exercise power under 356. Please appreciate.
But suppose for a moment that they had not gone through this exercise of amending 367, all right, or introducing 367-4. And suppose we are operating purely within the fold of 356.
Yes,
All right, your challenge to the 356 notification is a different issue.
yes.
You're now just testing it as an exercise of power under
Very-
356.
very good.
Once a proclamation takes place under 356, two consequences follow. One, the president assumes to herself all the powers of the state, the executive powers of the state vest in the president. Two, except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the president.
Correct,
All the powers of the state legislature were vested in parliament.
right.
Now, if that was so, then if 370(3) is capable of the interpretation, just as a hypothesis, that it's a power to be exercised by the president to abrogate. They abrogate. Point number two, any powers which were to be exercised by the state legislature would have to be exercised by parliament, so they had to go to parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by parliament, by the governor, by the president and parliament in this fashion. Independent of 367, cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature under 356. That's, Bomai has held that. You have no such powers. And the executive is only dealing with the administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. I'd show Manas Bomai.
Yes, but assuming for a moment that we suppose we disregard the 367 amendment.
Even if you do, then you can't exercise it under 356 at all. That's even, Manas, it will be a dead letter. It'll be inchoate. Because you can't amend constitutional provisions, Manas, through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough. Therefore, if that part of the notification, which amends 367, is kept aside for a moment,
Yeah.
then what is the consequence?
The consequence is that 356 power cannot be exercised in the same fashion to
No.
achieve the same result.
See, the 356 power is the power of the state legislature
Yes,
and the state executive,
yes,
which has now been vested in the president and in parliament, respectively.
correct.
You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the constitution by taking recourse to 356? Fair enough. We got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue, Malad. I'll address your lordships on that.
Right.
At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later, Malad. Because ultimately what you then do is Parliament is exercising power as a legislature and Parliament is exercising powers under 356 as well. Correct, Malad? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373.
I think what they believed was they proceeded on a particular hypothesis that consultation with the constituent assembly is necessary.
That's right.
So therefore, they said that, all right, we are now going to replace the word constituent assembly by the word legislative assembly, which they sought to achieve by amending the constitution.
No, it's the recommendation of the constituent. It's not
Yes.
just converting it. You can't.
The
therefore
first
you
step was to
recommend-
amend the constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it, and Mullahs, you take the decision yourself.
Yes.
These are very problematic, Mullahs. And see the consequences of this. That means through an executive order, you can change any provision of the constitution because you have majority. But this majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the constitution.
Exactly.
That point you.
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullahs, now one of your esteemed colleagues has said, Mullahs, that in fact basic structure, those theory is also doubtful. Maybe it is.
If we
After-
refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course, it's not binding, Mullahs, but I'm surprised.
On 11th of November 19.
Parliament doesn't discuss what goes on in the court.
No, I'm not
Court
discussing
should not-
anything.
I am not discuss what goes on in Parliament.
No, I'm not
And
discussing.
everyone, my lord, has a freedom
This
of
is a public.
view, freedom of expression.
No, I know. Mullahs, I assume he has the freedom of expression, what he likes. I don't dispute that, Mullahs. I'm just saying, Mullahs. Of course, absolutely. We're starting a debate on that because of this majoritarian culture again. I said that 356 was already in place.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the Parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have learned,
You are right.
expressed
You're right.
his views on basic
No,
structure.
not my view. I'm not, my view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court, Mullahs. In court, I have that constitutional view. Outside may have a different view. Mullahs, anyway, that's neither here nor there, Mullahs. It's just an aside, Mullahs. But there must be some element of humor and mirth in court as well, Mullahs. Not everything can't be this serious.
Yes, Mr. Pal.
Mullahs, therefore, see the consequences of this. And Mullahs, then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing. And it says shall read. This is an interpretation clause. Please appreciate 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. You can only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
What they've done is,
Very mature. Yes. You're right. No, my lords,
So we saw this notification. Then what happened thereafter? We got your submission on this.
well, I just wanted to, my lords, mention this. Your lordship at one stage said the Legislative Assembly could be the Constituent Assembly.
No, no, no.
Legislative Assembly
No.
is a
No,
successor
that
to the
is
constituents.
this is, we were saying what amendment they made. We didn't make a postulation that the Legislative Assembly could be the
Well,
one.
your lordship said that as a consequence, now that there is no Constituent Assembly, why can't the Legislative Assembly?
No.
Anyway, I was a mistake. I'm sorry.
That can never be a.
That's good, that's good. Anyway, Malad, let's move on, Malad. Let's move on. Now, Malad, I want to show your lordship the original 367.
Yes.
Original 367. That's in volume 1, PDF page 194, Malad. Page, Malad, PDF 194, volume 1. That's the original 367 before the amendment, as applicable in Jammu and Kashmir. Then
Page,
your lordship will be
what
like
page, Mr. Subbu?
194. Malad. Starts at 193, the 367 says interpretation, but the clause 4 is at 194.
Yes.
If I may read, for the purposes of this constitution, my Lord Justice Kaul has it?
Yes.
For the purposes of this constitution, as it applies in relation to the state of Jammu and Kashmir, reference to this constitution or to the provisions thereof shall be construed as reference to the constitution or the provisions thereof as applied in relation to the said state. No problem. Then references to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as the Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And then, Malad's references B, reference to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. So mark that one. That was changed. No. Provided that in respect of any period to the 10th day of April 1965, such references shall be construed as including references to the Sadr-e Riyasat acting on the advice of the Council of Ministers. Because originally the Sadr-e Riyasat had to, till 1965, had to be appointed on the recommendation of the Assembly. A name would be sent and they would agree. In 65, a change was made, in terms of which, Malads, the President could directly appoint the governor. That change happened in 1965 in the Constitution of Jammu and Kashmir. So like any other state. So slowly, in any case, Malads, there was a slow but sure obliteration of the kind of autonomy that Jammu and Kashmir enjoyed. All laws were applicable, including TADA, POTA, UAPA, all laws are applicable there, except for land laws and personal laws, Malads. Most laws of India are applicable there at that point, in this point in time, in any case. So there was actually no need for any of this, except with the objective of sending a political message that we have done away with 370. That's why all this was done. Now, that's my submission.
Actually, after 2019 exercise, approximately 1,200 laws are now applicable. All beneficial legislations which are available to other citizens now are available to Jammu and Kashmir also. Prevention of Corruption Act was not applicable. Right to education.
There was. My learned friend is not right.
Several laws.
Anyway,
we have the list.
let's not go into that. Let's not go into that. Prevention of corruption law was applicable.
You're right, Mr. Dwivedi. That's not a constitutional point, but
Political optics all laws were applicable.
Just
Therefore,
to set the record right, the Jammu and Kashmir Prevention of Corruption Act, Samvat 2006, applicable. So it's because they were named differently. Anyway, let's leave that. Let's not get into this. References to then D, Malas. References to the permanent residents of the said state shall be construed as meaning persons who before the commencement of the constitution application to Jammu Kashmir order were recognized as state subjects under the laws in force or who were recognized by any law made by the legislature of the state as permanent resident. Reference to the governor shall include references to the governor of Jammu and Kashmir, provided that in respect of any period prior to 10th April 1965, such references shall be construed as references to the person recognized by the president as the Sadr-e-Riyasat of Jammu Kashmir and as including references to any person recognized by the president as being competent to exercise the powers of the government.
Actually, they say in this notification of 5th of August 2019 that they're adding clause 4 to Article 367.
That's right.
But it appears that clause 4 already existed in Article 367. So it was really
But
an
they
act of
substituted-
substitution, not an addition.
Not added.
That's a
They
small thing,
substituted.
but it's a substitution really.
Correct. But clause D is in addition, where the Constituent Assembly must be read as.
C remains the same, right? C remains the same.
D is different.
D
entirely.
is different, you're right.
And Miller's 2 also is also different. All provisions of the Constitution amended from time to time shall apply in relation to Jammu and Kashmir. And the exemptions and modifications subject to which they shall apply shall be as follows. All provisions of the Constitution
And
are now.
old clause D goes, the references to the permanent residents of the state,
Yes.
that goes.
That goes.
Because that D is now substituted by the Legislative Assembly being treated as the Constituent
That's
Assembly.
correct. That's correct. So that's what happened. Let's go back to this.
Well, there are 2 different stands operating here. One stand arises out of the exercise of the power under 356.
Correct.
Under 356, you have no power to amend the Constitution.
Right.
If you exercise the power under 356 in relation to any other state in India, you can't amend the Constitution. 370 is a provision exclusively in operation in relation to Jammu and Kashmir at the relevant time.
Correct.
So the power which they were exercising was the power under clause D of subsection 1 of clause 1 of Article 370.
Correct. Absolutely right. But unfortunately, Millers, they couldn't do that because clause 1 dealt with instrument of accession, subject relating to instrument of accession, and then in concurrent list issues.
No, clause D is wider than that.
Wider.
You're referring to clause A. We're referring to clause D.
Yes, I'm reading all clause A also.
D requires the concurrence of that government.
That's correct.
That is the J&K government.
That is government means government council of ministers, Millers. Government is not under the.
But tell us what happens when there's a 356 in operation in the state of J&K?
Well, let's put it this way, Millers. How does 356 in normal circumstances happen? Millers, the governor sends a report. The report is that the provisions of the Constitution cannot be carried on in this particular state. The government of India under 356 Millers takes over.
Right.
Right. Now, at that time, the assembly is in suspended animation. That's the normal way that it is done. You keep the assembly in suspended animation, you exercise your powers. Ultimately, the intent is to restore democracy. Therefore, Millers, towards the end of it, when you know that elections should be held and you want restoration of democracy, you dissolve the assembly. And then you hold elections.
Oh, well, Mr. Sibal, the question put was slightly different. Now come to 370 clause D.
Right.
Such other provisions of the Constitution shall apply in relation to the state subject to exceptions and modifications that the President may by an order specify. Now, as far as this is concerned, therefore, the amendment was made to clause 4 to section 367, which is the interpretation clause. Now, the proviso says, provided further that no such order which relates to matters other than those specified in the last proviso, preceding proviso, shall be issued except with the concurrence of the government. The
Right.
concurrence of the government is the explanation
That's
part.
the concurrent list subjects.
No, concurrence of the government
And the
is
Constitution,
the,
both
the
the
legislative.
Constitution of India as well as concurrently.
Let's assume Council of Aid and Advice of the Constitution of Aid and Advice of the Council of Ministers for the time being in office.
Yeah,
Now, when we turn to 356,
yeah.
now 356 applies.
Yes.
356 applies.
Of course, of course.
Now, if we turn to 356, then we have to go into what is the power, if 356 provision has been invoked, who will exercise the power of the Council of Ministers under the terms of Article 371.
Right.
So now the issue would be whether the governor could have exercised that power or not.
But at the moment, I have not reached 356, Malad. May I make my submissions when I reach it, Malad?
Okay.
This is, I will delve into another.
No, we are not on the
Yes.
validity of 356.
Exactly.
We are on the question of power.
Malad,
itself.
I'll be dealing with the power of 356, Malad, when we come to 356. What happens is that I will ultimately, Malad, my trend of thought will
They
be
get
just-
disturbed.
because I have.
But we just formulate it and leave it at that, that once upon the proclamation under 356, all the powers of the government of the state are vested in the president.
Administrative powers,
Yes.
administrative.
Then can the president, in the exercise of the second proviso to clause D of Article
Amend the
371,
Constitution.
no, not amend the constitution,
Yeah.
exercise the power to grant a concurrence?
Concurrence.
Malad, concurrence, what? Which subjects? Please appreciate. Either the applicability of the Constitution, right, with modifications and exceptions, or Malad's applicability of list in the concurrent list. That's all. That's all that there is. It can't be more than that.
And the president has the power to issue an adaptation order.
Yes,
Under the second proviso to clause D, the president can issue an adaptation order.
correct.
When you have a regular government and a legislative assembly in place, you require the concurrence of the government,
Correct.
right?
Yeah.
Now, where the power of the government has been vested in the president under 356, it
Yeah.
cannot be that the power of the president to issue an order of adaptation is taken away.
Correct.
Now, who will exercise that power, that power
Let's
of
assume the
concurrence?
president is, it can't be contrary to to clause D of the 373D. It can't be that, Malad.
No, but
That power can't be
370,
exercised by the
370, no, Mr. Sibal, 370D says that no such order which relates to a matter other than referred to in the last preceding clause shall be issued except with the concurrence of that government. Now, that government means the state government.
It
Now,
means
what-
Council of Ministers.
Council of Ministers. Now, what happens when a 356 notification is issued?
Malad, please.
In which case, will we say that that power cannot be exercised at all by the president?
I'm going to, I'll answer that then. Malad, kindly read Malad C and D, such of the other provisions of the Constitution. That is excluding Article 1 and 370.
Well, under D, the president has the power to issue adaptations of the constitution, which are all these orders that we are now seeing.
The other provisions of the Constitution, it says, D says that, Malad.
Right.
Much of the other, excluding 1 and excluding 370. This is an amendment of 370 itself. How can the president exercise that power under D?
No, we are now looking at the exercise of the power to substitute 367.
Yes, but that effectively is the amendment to the Constitution,
The,
to C70.
Mr. Sibal, the president has the power to amend the constitution or create exceptions by taking recourse to the power under clause D, the second proviso. The president has an unquestioned power to do it.
Yes.
When there is a government in existence, it is conditioned by the requirement of concurrence. Now, what happens when the government has been superseded under 356? I'm just using superseded in a loose expression. If the government has ceased to exist by the exercise of the power under 356, The entirety of the power of the government is now vested in the
But
president.
even the government cannot change Article 1, 370, Millards. Jammu and Kashmir Legislative Assembly can't.
You're right, absolutely. Therefore,
The executive can't go beyond that.
you're right. Therefore, the government also has no power to amend 370 by itself.
No, can't change the scheme of 370. Forget about amendment.
But 370 itself postulates that it can be abrogated and
These 370 say that it can postulate to efface Article 3, then I have no answer.
No,
Then I have no answer.
Mr. Sibbal, the question was slightly different. The question is slightly different. Now, under clause D to section 371,
Yes.
the president by an order can make modifications to the provisions of the constitution as they apply to that state.
Well, please, I'm sorry to interrupt your lordship, but read the first part. Such of the other provisions of this
Correct, I'm coming
So
to
the
that.
modifications can only be.
We have understood that, just for the time being, just leave that argument apart, because one way to interpret clause C to section 3, article 371 is that it is only saying 1 and 370 will certainly apply to the state of Jammu and Kashmir. D refers to such other provisions of the constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may by an order specify. For the time being, we are referring to 367, because the power under 367, there was 367(4), which was applicable even at the time of, in 2019. There was clause 4 of article 367, which was certainly applicable at the time, even in 2019.
Yes, yes,
Now, if, in order to make modification to that clause,
yes.
during, when 356 is invoked, what will be the procedure?
But that's an interpretation clause. That's not a clause to amend the constitution. I mean, I don't understand, Malad. I mean, obviously, I've gone something wrong in my understanding of the plain reading of the section, Malad. Obviously, I'm completely wrong, but with greatest respect, Malad, that's an interpretation clause.
Interpretation clause cannot be amended.
No, by interpretation clause, you can't amend 370. That's the power, with great respect, Malad. You can't substitute the legislative assembly, constitute a legislative assembly. What has that got to do with interpretation? What you can't do directly, you can't do indirectly, Malad. And where does the president get that power when it says such of the other provisions of the constitution shall apply in relation to the state subject to such exception? That means other provisions of the constitution, you can have exceptions and modifications, not exception and modification 370. So I will not amend 370, but I will amend 367 to amend 370. Well, with the greatest respect.
In your argument on that as well. 367(4), one second, 367(4) was brought in for the first time, not with the constitution, but in 1954. Right? So when 367(4) is brought in, if your argument is right, then the original insertion of 367(4) is also invalid.
No. That was interpretation. But this is Damru. That's a case directly on point where your lordships have said governor was always known to be the governor. Sadr-e Riyasat was only the name. The argument was Sadr-e Riyasat prior to 1965 had to be elected.
Right. But
yes. That's straight away. Had to be elected. But in fact, now the governor was directly appointed by the president, right? He didn't have to be elected. So merely because there's a change of nomenclature, but if you change the substance of 370, considerations would be entirely different.
That's the submission.
That's held by your lordships. So let's not. There was no fundamental alteration there. Here there's a fundamental alteration. What you can't do directly, your lordships are now saying that let's look at 367. It's hard to find an alleyway to reach a logical conclusion. One can try very hard. But as I get lost when I go to my own
let's put it very simply.
lost in alleyways.
Let's put it very simply. When Article 356 is in operation, how will you effectuate clause 4 to Article 370 clause 1, according to you?
I will, Malad. Please let me reach that stage. I've tried to answer all your questions so far, Malad. I'll answer that also.
So now we have seen the, that notification of
Manoj,
5th of August and the original Article 367.
370, please remember. It says notwithstanding anything in this constitution at the beginning, and then it says notwithstanding anything in the foregoing provisions. 356 doesn't begin with that, with a non-obstante clause. It's important to know that even 373 says notwithstanding the above provisions. So it's notwithstanding of notwithstanding. So then how do you exercise that power in any other way? 366 has to be subject to 370. Doesn't say notwithstanding any provision of the Constitution, I can do what I like. Okay, you go back to Malak's, what we tried to get rid of in 1950.
To now say yes.
Notwithstanding.
But that's why I said, no,
Yes.
This is now volume 2 of written submissions and PDF page 53. I was at item serial number 73.
Volume 2 written submissions.
73 minutes, 5th of August, PDF page 53. So the second paragraph at 70, members of the House raised objection.
Just 1 minute.
PDF, Mr. Sibal.
53, Malak, 53. Members of the House, my lords have that, raised objections that the bill had not been circulated. Then if and when the bill is circulated, time be allowed for reading and understanding the bills, and that only after the bill had been introduced was the supplementary list of business circulated in the House. The statutory resolution raised Jammu and Kashmir Reorganization Bill 2019 provided that the President of India had referred the Jammu and Kashmir Reorganization Bill 2019 to this House under the proviso to Article 3 of the Constitution of India. Just let's pause here for a minute. Now, if you look at Article 3, your lordships will find Constitution. as Constitution of India as applicable to the state of Jammu and Kashmir. This is document volume 1, PDF page 66. This is important, Malad, because remember, this is the 5th of August. The law, the bill is passed on the 6th of August, but introduced on the 5th of August. So if you go to the Article 3 of the Constitution as applicable, you will find that the second proviso says, provided further, if our lords have that?
Yes.
Provided further that no bill
Mr.
providing.
Sibyl, just 1 second.
I'm sorry.
Volume 1.
This is PDF 66, volume documents, volume 1.
Yes, Mr.
It says that provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So there is no legislature, there is no legislative assembly. Governor has dissolved on the 21st of November, the assembly. You have to introduce the bill only with the consent, concurrence of the legislature. You introduce the bill contrary to the article. Because he says this is suspended, nothing exists. But by this time it's dissolved. How do you do that? Every executive act is constitutionally flawed, impermissible. It's a violation of the fundamentals of constitutional law.
Yes.
First proviso says that provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area boundaries, name and states, the bill has been referred by the President to the legislature for expressing its views thereon. So the first proviso dealt with in other states like Telangana when they were created. It had to go to the legislature for expression of views. Government of India may not. Parliament may not agree with those views. That's, of course, the power of Parliament given by the Constitution itself. So they introduced a bill without the legislative consent. I'll come to the reorganization bill later, but I just wanted to mention, because we are on this list of dates, that this itself could not have been done. Now, let kindly come back to my volume 2 written submissions. Let's skip this one. Yeah. Was not the legislature.
Governor's consent was taken.
Had to be, Malas. Not that we know, but yeah, it was. That's right. That's right. No, I'm sorry, Malas. Yeah. Yes, yes. The proviso And then they gave consent themselves, took their own views. Well, they had to take the views of the legislature, they removed the proviso and took their own views. And on the basis of that. That's power. Yes, yes.
But give us the sequence. You told us last time, I think 19 December 2018, which was the documents compilation, volume 3, page 92. When the proclamation under 356 was issued,
That's right.
they
20th
suspended the
20th of-
provisions of the state constitution and proviso to Article 3 was also suspended.
That's right.
That's step one, right?
That's step one.
Then thereafter,
President's rule was extended from time to time.
yes,
On 3rd July, it was extended thereafter. And on 5th August, this happened,
5th of August, 19.
19. So originally, Mullah's 19th of June, just to get 2-3 facts right, 19th of June, Mullah's BJP withdrew support. 20th of June, Governor exercised the powers to keep the assembly in animated suspension. 20th, the very next day, he didn't explore the possibility of a government being formed. Now, he had to necessarily, under the Jammu Kashmir constitution, hold elections within 6 months. When there were some attempts made in December to form a government, November, to form a government between the National Conference as well as PDP, immediately on 19th December, 21st November, he dissolved the assembly. The 6 months were not yet over.
So what is the date of that?
On 21st of November.
21st of November 2018.
18. He dissolved the
And
assembly.
can you just ask one of your juniors to give us the page reference?
I'll do that. Page reference.
Because last time some of the other we didn't take.
In a second one. My colleagues are adept at that. Volume 3, PDF page 89. Volume
3,
PDF page 89. November 21st, 2018, order. Here is what he says is, by virtue of powers vested upon me in terms of proclamation so-and-so 20th June 2018, issued under subsection 1 of 92, and in exercise of powers conferred upon me by clause B of subsection 2 of 53 of the Constitution, I hereby dissolve the Assembly.
Then comes 19 December 18, proclamation under 356.
That's right.
And the president suspends the proviso to Article 3.
Correct.
That's the next step.
Page 92. PDF page 92.
Yes, document compilation 3, we got that.
Then it's extended till 3rd of July. That's at page 95. PDF page 95.
Extension till?
For 6 months, Mother. From 3rd of July. And in between 5th of August, this happens, between the 6-month period.
Six months was to end, is it?
Yes.
5th of August, he introduces it, Mother. First on 5th of August is the amendment order, Mother.
Yes, we saw the amendment order.
And then Bharat introduces this. Now, I'm going to not deal with the reorganization bill at the moment, Bharat. We come therefore skip the date and come to CO Order 273, serial number 77. Now, we have seen CO Order 272, which I showed to your lordships, which is under challenge. That's the executive power as exercised by them, which substitutes, Bharat, 367. That is CO 272. Now it's the CO 273.
You are back to we are in the
List of dates,
Yes.
volume 2, written submissions, written compilation, and serial 77. I've skipped the ones in between.
Okay.
Sure, 1 minute. Sure, once I read it. All my lords have it, Malad?
Yes.
The president issued CO 273, which is also impugned, which is also an executive order in exercise of power under 370 sub-article 3 of the Constitution as amended by CO 272. Declared that Article 370 would cease to apply with effect from 6th of August 2019. So again, through an executive order, they passed an order saying this particular article will cease to apply. These are not legislative acts. But this is in volume 3, PDF page 103, the documents volume 3. What? Yeah, declaration. It's a declaration, not an order.
Declaration under Article 370.
Under Article 370 sub Article 3. How does which power does what power does the president have to make such a declaration? Which provision of the Constitution? In exercise, my lords have that? This is PDF page 103. Document volume 3. Does it show in that? Do you not see that?
It's reproduced in the Berect also.
Okay, okay. Maybe sometimes easier. Let's just have it. In exercise of the powers conferred by clause 3 of Article 370, read with clause 1 of Article 370 of the Constitution of India, the President, on the recommendation of Parliament. Now, let's see this. So Parliament, that is, acting under 356, becomes the Legislative Assembly, recommends to itself, exercising the powers under 370, as a constituent assembly, and then says that 370 ceases to exist. So you Malads therefore assume all the powers of the state legislature, of parliament, of the constituent assembly, and give consent to yourself. Recommend to yourself and accept the recommendation yourself. So amazing exercise of constitutional legerdemain. Therefore, he says, Miller, that all clauses of the said Article 370 shall cease to be operative except the following, which shall read as under, namely, all provisions of this Constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or 308 or any other article of this Constitution or any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under Article 363 or otherwise. Go back, Mullahs, to the list of dates.
They accepted the J.
So now we have time.
12:56.
6. So I know, I know, I know.
Yes.
There's a very serious thing that's happened in Gurgaon, mothers, where mothers, there is a call along with policemen to say that if you employ these people in these shops, you will all be gaddars. You know, that this is creating, so if we file an urgency petition, we also may look at it at lunchtime. That's all.
check, mic check, check.
I just want my lords and others to look at documents volume 3, PDF page 104. Documents volume 3, PDF 104.
That is the acceptance by Parliament.
Yes,
Of the
but he
reorganization.
moves the resolution, Millet. Amit Shah moves the resolution. Just important to read it.
Supplementary list of business.
Yes. Says that the President of India has referred the Jammu and Kashmir Reorganization Bill to this House under the proviso to Article 3 of the Constitution for its views. For its views, as this House is vested with the power of the state legislature of Jammu and Kashmir, as per the proclamation of the President of India dated 19th December 2018, this House resolves to express the view to accept the Jammu and Kashmir Reorganization Bill. And then Millard's the speech to the statutory resolution and what he says when he moves it. That's at page PDF 105, that this House recommends. So that's the understanding throughout. This House recommends the following public notification to be issued by the President. An exercise of the powers conferred by clause 3 of 370, read with clause 1 of 370, the President, on the recommendation of Parliament, is pleased to declare that as from 5th August, all clauses of the said Article 370 shall cease to be operated, except clause 1 thereof, which shall read as under, that all the provisions of this Constitution as amended from time to time, without any modifications or exceptions, shall apply the state of Jammu and Kashmir, notwithstanding anything contrary contained in 152 or 308, or any other article of this Constitution, any other provision of the Constitution of Jammu and Kashmir, or any law, document, judgment, etc. The President has referred the Jammu and Kashmir Reorganization Bill to this House under the proviso to Article 3 for its views. And then
the presidential notification,
Correct.
which is page
So,
1.
just one other thing, and then if your lordships kindly come back to the first CO202, just for a minute, Mullah.
What page would that be?
Yes, 101, PDF 101. Is it?
Of this document one is what?
PDF 101, same document, volume 3, same one. Just above this.
Page 494.
Yes. So it's not just the substitution of definitions. It's much more than that. I just wanted to point that out. That in exercise of the powers conferred by clause 1 of 370, the President, with the concurrence of the state of Jammu and Kashmir, is pleased to make the following order. He makes that order, and that it shall come into force at once and shall thereupon supersede the Constitution application to Jammu and Kashmir Order 1954 as amended. So it's not just 367. And then all the provisions of the Constitution as amended from time to time shall apply to the state of Jammu and Kashmir, and the exceptions and modifications subject to which that shall so apply shall be as follows. So will they supersede the 54 order, apply all the provisions of the Constitution, and then the 367. So it's not just the interpretation clause. That's all I wanted to point out. Now, let's kindly come back to the list of dates so that we can, that is written submissions compilation volume 2.
Yes.
And we were at 77. We've already read 77 in the sense that I have read it from the Amit Shah's, from the Home Minister's, the introduction. And then Millet 78 is 9th of August 2019, in exercise of the powers under Section 2A of the Jammu Kashmir Reorganization Act. On receiving the assent of the President, the respondent through the Ministry of Home Affairs issued a notification for the provisions of the Act to come into force with effect from 31/10. Then, of course, the writ petition is. Sorry. I'm sorry.
And then the petition and then,
And then, Millet, 31st of October, pursuant to the notification SO 2A.
the bifurcation into Ladakh and
That's,
Jammu and
that's,
Kashmir.
so that's what happened. So that's all, Millet, the facts are concerned. Everything. Now, Millet, kindly.
Yeah.
Just, so therefore, we are dealing with three issues. 356 power, CO202, CO203. 273. Now, just let's keep three principles in mind, which are going to be my key submissions. It's my submission to your lordships that when interpreting all these executive orders and the Constitution, three principles must be kept in mind.
Yes.
The first is that the clear language of these provisions in its structural and historical context. The clear language of these provisions in its structural and historical context ought to be given effect. And it is our contention that the language of the provisions is clear, unambiguous, and on its own terms must be given effect. You can't find ambiguity where none exists. So that's the first principle. Yes. Second, if there is a textual ambiguity, the court should not be adrift in a sea of pragmatism. And the court must interpret that.
If there is structural ambiguity,
If there is any textual ambiguity or the possibility of trying to find another possible interpretation, let's put it that way.
The court should not be adrift in a
Adrift
sea
in the sea
of
of pragmatism.
And
And Malaj, the interpretation that is more consistent with our constitutional values. An interpretation that is more consistent with our constitutional values, namely representative democracy and federalism. Representative democracy, federalism, and constitutional morality should be preferred.
Could you repeat that again, Mr. Simbal?
Whereas that if there are, if the
Second part.
if there is a textual ambiguity or a possible alternative interpretation by stretching your mind a bit, then we must interpret those provisions. We're not adrift in a sea of pragmatism. We must interpret those provisions consistent with constitutional values, federalism, representative democracy, and constitutional morality.
that's the second.
That's the second.
And the third?
That will ensure the smooth and harmonious functioning, working
In fact, that's the third one.
of the Constitution.
Written submissions which you given.
Now, I'm just putting it, and the third is that any power vested by or under the Constitution is in essence, a limited power. There is no unlimited power, Malad, vested in any institution under the provisions of the Constitution. It's a limited power. It is limited at the point of time when it is exercised. It is limited at the point in time when it is exercised. And limited by core constitutional principles or values, both in terms of time and core constitutional principles and values. Since no power is absolute.
Yes.
And therefore must be exercised in accordance with the provisions. This is my fundamental premise, on the basis of which your lordships, I beseech, will try and interpret the Constitution in the manner that I have suggested.
Yes.
So, if you look at it from the standpoint of these principles, and you apply them to Article 3, Article 356, and Article 371D. Apply these to these three articles. This is the exercise of executive power.
356.
371D, Manas. The answers, according to me, are evident. Why? I just presently say. The power under 371D does not extend to abrogating 370. By applying those three principles. The power under 356 minutes does not extend to making non-restorative, permanent alterations, non-restorative permanent alterations to the state's constitutional status. That's on Malat's 356. And the power under Article 3 does not extend to effacing the character of the state into a union territory. The power under Section 3, Article 3, does not extend to effacing the character of a state into a union territory. So therefore, it is the interaction.
Yes.
Interactive dimensions, the interaction of the values of constitutional values and federalism, separation of powers, and democracy itself that are at play. And that's, with the greatest respect, how your lordships be kind enough, and therefore, the question that arises is there a limit to the emergency power, or is it unlimited? That's what they are trying to do in using 356 to change the whole structure. So is it unlimited? Can emergency be passed to make used to make permanent constitutional changes? Is it an unlimited power? Can it be used to make permanent constitutional changes? Permanent and irreversible. And can the constituent power be equated with ordinary powers. Effacing the source of their authority. Constituent power is a separate genus of power. Can it be equated with ordinary legislative power? It can't. And can constitutional change, last of all, happen without consultation with the people, despite consultation with the people of Jammu and Kashmir, despite an express provision in that regard? And last of all, can the state be downgraded to a union territory by the union on its own whim and fancy without consultation with the people affected? Those are the constitutional parameters that I respectfully state should apply when dealing with this momentous change that was brought about by exercise of majoritarian executive power. Now, Malad, I'll take your lordships with some of these decisions. First of all, Malad, 356. Let me, Malad, straight away come to 356. We'll come to Bomai, Malad. Volume 2, Case Law Compilation. Volume 2, at PDF page 120. 113, sorry, Malad. 113 first. 6. Oh, yes, 113, sorry. No, that's right, 113. PDF page 113. Yeah. Paragraph 96.
Volume 2.
Justice Jeevan Reddy's judgment or
Says,
Justice Sawant?
yes. Justice Sawant. Now, the para 96, my lords have that?
Yes.
It will be inexcusable, it will be an inexcusable error.
113.
113, running page 267. 7.
CLC.
May I read, Malad?
Para 96.
96. It is inexcusable, it will be an inexcusable error to examine the provisions of Article 356 from a pure legalistic angle and interpret their meaning only through jurisdictional technicalities. The Constitution is essentially a political document, and provisions such as 356 have a potentiality to unsettle and subvert the entire constitutional scheme. The exercise of powers vested under such provision needs therefore to be circumscribed to maintain the fundamental constitutional balance, lest the Constitution is defaced and destroyed. This can be achieved even without bending, much less breaking the normal rules of interpretation. If the interpretation is alive to the other equally important provisions of the Constitution and its bearing on them, democracy and federalism are the essential features of our Constitution and are part of its basic structure. Any interpretation that we may place on Article 356 must therefore help to preserve, not to subvert their fabric. The power vested de jure in the President, but de facto in the Council of Ministers, under 356 has all the latent capacity to emasculate the two basic features of the Constitution, and hence it is necessary to scrutinize the material on the basis of which the advice is given, and the President forms his satisfaction more closely and circumspectly. This can be done by the courts while confining themselves to the acknowledged parameters of the judicial review as discussed above: illegality, irrationality, and mala fides. Such scrutiny of the material will also be within the judicially discoverable and manageable standards. So that's the first paragraph. Then 106, PDF 119. Thus, the federal principle, social pluralism and pluralistic democracy, which forms the basic structure of our Constitution, demands that the judicial review of the proclamation under 356 is not only an imperative necessity, but a stringent duty, and the exercise of power under the said provision is confined strictly for the purpose and to the circumstances mentioned therein, and none else. That's very important. The purpose of 356 is to restore democracy. That is why this is very important. So you must interpret whatever the actions of the government are in the context of that purpose under 356. It also requires that the material on the basis of which the power is exercised is scrutinized circumspectly. In this connection, we may refer to Dr. Ambedkar, what he had to say in reply to the apprehensions expressed by other honorable members of the Constituent Assembly in this context, which also brings out the concerns weighing in the mind of honorable members. In regard to the general debate which has taken place, in which it has been suggested that these articles are liable to be abused, I may say that I do not altogether deny that there's a possibility of these articles being abused or employed for political purposes. So this is not something that I am saying on my own, Mullah. This was envisaged. But that objection applies to every part of the Constitution, which gives power to the center to override the provinces. In fact, I share the sentiments expressed by my honorable friend, Mr. Gupte, yesterday, that the proper thing we ought to expect is that such articles will never be called into operation, and that they would remain a dead letter. If at all they are brought into operation, I hope the President, who is endowed with these powers, will take proper precautions before actually suspending the administration of provinces. I hope the first thing that he will do would be to issue a mere warning to a province that has heard that things were not happening in the way in which they were intended to happen in the Constitution. If that warning fails, the second thing for him to do will be to order an election, allowing the people of the province to settle matters by themselves. It is only when these two remedies fail that he would resort to this article. It is only in those circumstances he would resort to this article. I do not think we could then say that these articles were imported in vain or that the President had acted wantonly. Time and again in the history of this country, 356 has been misused by all regimes. That was never the intent. And now, in this, in changing the structure of this Constitution as applicable to Jammu and Kashmir, it has crossed all limits. See what happens. 20th of June, Maharaj, 19th of June, sport withdrawn. 20th of June, governor says, and suspended animation. 20th of November, an attempt is made. Well, there is some ambiguity in that, to form a government. 21st November, dissolution. Can't be done without the aid and advice. Then, my lords, after 21st November, 19th December. Then 356. Then 3rd of July. Extended. Then 5th of August. Where are the steps for the restoration of democracy? Where are those steps? In fact, the steps are just to the contrary, the reverse of it. Destruction of democracy. People are not taken into account. Their views are not taken into account. You arrogate to yourself the powers of the state. You arrogate to yourself the powers of the legislature. Parliament becomes the spokesperson of the people of Jammu and Kashmir. And you express the wishes of the Jammu and Kashmir Assembly through Parliament. When the Constitution requires you to take the views of the state, of the legislature, of the people of Jammu and Kashmir, who gave to themselves the Constitution of Jammu and Kashmir. Everything that is done under 356 is contrary to the basic principles of both federalism and democracy, and to the principle of constitutional morality.
Yes, please.
Then 108 minutes. The further equally important question that arises in this context is whether the president, when he issues a proclamation under 356, would be justified in removing the government in power or dissolving the legislative assembly, and thus in exercising all the powers mentioned in subclauses A, B, and C of clause 1 of Article 356, whatever the nature of the situation or degree of the failure of the constitutional machinery. A strong contention was raised that situations of the failure of the constitutional machinery may be varied in nature and extent, and hence measures to remedy the situation may differ both in kind and degree. It would be a disproportionate and unreasonable exercise of power if the removal of government or dissolution of assembly is ordered when what the situation required was, for example, only assumption of some functions or powers of the state, government of the state, or of anybody or authority in the state under 356(1)(a). This is not the only power that you can exercise under 356. There are incremental steps to be taken. This is not a guillotine provision. And it's temporary, to say the least. So unless your lordships come down heavily, that 356 is not meant for this purpose. The excessive use of power also amounts to illegal, irrational, and mala fide. So your lordships will have to determine, was this not an excessive use of power? And per se, it would be illegal, mala fide, and irrational. Hence, it is urged that the doctrine of proportionality is relevant in this context and has to be applied in such circumstances. To appreciate, that's why I said, in normal circumstances, dissolution would never happen. First, the assembly would be suspended, be in suspended animation. Attempts would be made to form a government. In the meantime, you exercise president's rule. When you realize that it's just not possible at all, it's then at that stage that you dissolve the assembly and order elections. Now you've dissolved the assembly. When did you dissolve it? On 21st of November, 2018. And we are where? In August 2023. Was that meant to be, under 356? Hence, it is urged that the doctrine of proportionality is relevant. To appreciate the discussion on the point, it is necessary to realize that the removal of government and the dissolution of the assembly are effected by the president if he exercises powers of the governor under 164, 174, respectively, under subclause A of Article 356, though that is neither necessary nor obligatory while issuing the proclamation. In other words, the removal of the ministry or the dissolution of the Legislative Assembly is not an automatic consequence of the issuance of the proclamation. The exercise of the powers under subclauses A, B, and C of 356 may also coexist with the mere suspension of the political executive and the legislature of the state. Subclause C of Article 356 makes it clear. It speaks of incidental and consequential provisions to give effect to the objects of the emergency, of the proclamation, including suspension in whole or in part of the operation of any provision of the Constitution relating to anybody or authority in the state. It has to be noted that unlike subclause A, it does not exclude the legislature of the state. Subclause B only speaks of exercise of powers of the legislature of the state by or under the authority of Parliament. What is further the assumption of only some of the functions of the government and the powers of the governor or of any body or authority in the state other than the legislature of the state under subclause A is also conceivable with the retention of the other functions and powers with the government of the state and the governor or any body or authority in the state. The language of A is very clear on the subject. It must be remembered in this connection that where there is a bicameral legislature, the upper house, the legislative assembly, cannot be dissolved. Yet under subclause B of 356(1), its powers are exercisable by or under the authority of Parliament. The word used there is legislature, not legislative assembly. Legislature includes both lower and upper house, legislative assembly and the legislative council. It is also to be noted that when the powers of the legislature of the state are declared to be exercisable by or under the authority of Parliament under 356(1)(b), it is competent for Parliament under 357 to confer on the President the power of such legislature to make laws and to authorize the President to delegate the powers so conferred to any authority to be specified by him. The authority so chosen may be by the union or officers and authorities. Legally, therefore, it is permissible under 356, firstly, only to suspend the political executive or anybody or authority in the state and also the legislature, and not to remove or dissolve them. Secondly, it is also permissible for the President to assume only some of the functions of the political executive or of any body or authority of the state other than the legislature, while neither suspending nor removing them. The fact that some of these exercises have not been resorted to in practice so far does not militate against the legal position which emerges from the clear language of 356. In this connection, we may refer to Dr. Ambedkar had to say on the subject of Constituent Assembly. The relevant extract from his speech is reproduced in para, which I've already read. Hence, it is possible for the President. Therefore, Mothers, we need not read it this really. And then, sorry, Mothers, the last paragraph. However, whether in a particular situation the extent of powers used is proper and justifiable is a question which would remain debatable and beyond judicially discoverable and manageable standards unless the exercise of the excessive power is so palpably irrational or mala fide as to invite judicial intervention. In fact, once the issuance of the proclamation is held and valid, the scrutiny of the kind and degree of power under this proclamation falls in a narrow compass. I just pause here. Whereas on the 21st of November, the governor had no power to dissolve Parliament. He could only do it under the on the aid and advice of the Council of Ministers. So see what they did. They knew that the Council of Ministers would never advise the governor to dissolve. So he dissolved it on his own. So if you dissolve it on your own, what are you left with? Only the governor. And then the governor, Mothers, did what he did. You impose 356 and then you take over the powers. And Mothers, ultimately, you are a delegate. 356 delegates the powers of the legislature to you. You're not an omnipresent, omnipotent authority to do what you like. You are a delegating. You've been delegated the powers of the legislature. What the primary institution cannot do, the delegate cannot do. So therefore, 356 was an extraordinary provision, allowing a progressive pathway for restoration. So what does that have done with this? Then
Mr. Sibbal, you can perhaps give us the paragraphs, you can read them if they are on the same drift.
Yes, I'll do.
Just give us the paragraphs so
I'll
that
just
we'll
give you
read
the
them later.
paragraphs. I'll give you the paragraph. Volume 2. Whereas therefore there's Justice Jeevan Reddy,
Which
para
paragraph?
268 and para 289.
Paras 268.
289, PDF 225. 268, 289, PDF 225.
Right.
Then Mullah's Justice Ahmadi, PDF 69.
PDF.
PDF 69, paragraphs 14, 16, and 23. Right? Yes, the rest I've read. This is what, yes, yes, the rest I've read. So this Mullah's completes
Yes,
350.
go. Yes. What is the next judgment now?
Now. No, we've already read it. Well, yes, there's a speech of Ambedkar on constitutional morality, which I just want to mention. That is November 1948. Compilation, volume 8. I'll just do that. Document compilation, volume 8. PDF 3. Oh, sorry. 15, 1-5. Sorry. Right.
I think I cited it in the first Delhi judgment, the NCT judgment 2018. Document compilation 8 page.
Page Mother's 15, PDF 15. Running page 2876 at the bottom of it. Yes, it's also quoted, Mother, in the Delhi matter. So my Lord doesn't, it's all right. We can move forward. So Mother, this is now, I've done with 356. We'll give your lordships the pages of the Delhi judgment also.
Yes, you can just give that.
Paragraph 284.
Where is the Delhi judgment? NCT?
Yeah, I'll just give your lordship the citation. Volume 5.
Case law, right?
Case law compilation, volume 5. PDF 2, where it starts. At paragraphs 284, 303, 284, 303, PDF pages 146 and 159. So PDF 146, 159, paragraphs 284, 303, right? So that's the Delhi judgment. Then, Mothers, I want to cite to your lordships Miller's judgment. That's important. I'll just give you 3 paragraphs of Miller's to just show where it is.
Yeah, it's volume 6.
Volume 6. Volume 6, PDF 384.
PDF?
Sorry. What was my mistake? I'm sorry, but it's my mistake. Sorry. Volume 5, it is not 6. PDF 308, volume 5. And I just 3 paragraphs of that judgment that I will
Volume 5.
Only 5 page number?
It's
308.
PDF page 30. It's a PDF page 323 of volume 5, straight to the paragraph that I'm reading.
Yes.
323, para 41, PDF. This is the case where, Mothers, the Queen was advised to prorogue Parliament. And 11 justices came down heavily, unanimous judgment. You can't just shut away discussion in Parliament. This is an extraordinary, Mothers, interpretation, showing that, look, you can't just show your back to the constitution, to the constitutional authority which has to deal with these issues. I mean, in our constitution, the right to prorogue is also given to the government. But of course, this principle is not really applied often. Now, C41, two fundamental principles, all your lordships have it, I'll read it. PDF 323. 5.
323.
I'm sorry?
320?
323, madam. Running page 1446 at the bottom. I'm just waiting for Justice Kaur. Two fundamental principles of our constitutional law are relevant to the present case. The first is the principle of parliamentary sovereignty. That laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply. However, the effect which the courts have given to parliamentary sovereignty is not confined to recognizing the status of the legislation enacted by the Crown in Parliament as a highest form of law. Time and again, in a series of cases since the 17th century, courts have protected parliamentary sovereignty from threats posed to it by the use of prerogative powers. And in doing so, have demonstrated that prerogative powers are limited by the principle of parliamentary sovereignty. In the context of Jammu and Kashmir, you use your prerogative power to erase the role of the legislature completely, to erase the opinion of the people of Jammu and Kashmir completely, to silence them through your own acts of majoritarian rule, which is a political act, according to me. To give only a few examples, in the case of proclamations, the court protected parliamentary sovereignty directly by holding that prerogative powers could not be used to alter the law of the land. Three centuries later, in the case of Attorney General versus Kaiser's Royal Hotel, 1920 appeal cases 508, the court prevented the government of the day from seeking it by indirect means to bypass Parliament in circumventing a statute through the use of prerogative. Exactly what's happened, Maharaj. In fact, much more, circumventing the Constitution.
So, Sibyl, in a similar discussion we'll find in a 7-judge bench judgment in Krishna Kumar Singh.
Yes.
On the power to enact, to promulgate ordinances. And the question was...
Your lordships have said.
Yes.
In that judgment.
Can you, though the power is limited by duration and time, can you bring about irreversible changes by the exercise of the ordinance making power? And we said you can't do that.
I've relied on that. Absolutely. If it were an act of Parliament, right, Malaj, the situation may well be different. Because then you would have to attack the legislation itself, if at all it is permissible. But you're not, you're doing something through your prerogative power. And making structural changes in an embedded constitutional structure recognized by Parliament then in 1950. That's the problem in the case. So 3 centuries later, the court...
We'll look at this. There's no difficulty. We'll look. Para 42, the first sentence of para 42.
41, and then there are
42, the first sentence is important.
42 and 50.
And 50?
50.
At page?
Which is PDF page 326.
Actually, para 50 is the...
So, just 50 is important. It's a very small paragraph. I'll just read it. At PDF, page 326. It says, for the purposes of the present case, therefore, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as a body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional clause. Anyway, so that's I'm done with Mr. Krishna Kumar, I'll give the citation only because it's your lordship's judgment.
17, 3 is the same.
Is it part of the compilation?
It's volume 21, Mulats. Yes, it starts at PDF 2 at that volume, in that volume, volume 21. And the relevant part, PDF page 82, paragraph 101.
Para 101.
Para 101. And 103, repromulgation in the present case, as well as 103. And that's PDF 83. PDF 82. So that's Krishna Kumar for your lordships. So that's, we've done with this. So this topic now we've done with. Now let's come to Mulats. That's that itself. I've said that. 356 is only for temporary emergency legislation. Anyway, Mulats, so now we come to Mulats, the judgments, because several of the judgments in JFK have interpreted these provisions. So I just want to bring, up to speed. Compilation Volume 1.
These are judgments on Article 370 itself.
That's correct. That's correct. Yes, this one. Yes.
Which is the first judgment?
Just give me a minute. PDF page 2, Mulats.
Which volume?
This is volume 1 of the judgments, Mulats. This is Lakhan Pal versus State of Jammu and Kashmir. First man. I intend to finish today, Mulats, so that.
Thank you, Mr. Sibal, for keeping to time.
Your lordship has been very kind.
I was going to tell you at 2 o'clock when we assemble, but sometimes, as a judge, you don't have the heart to do it.
No, I am very much.
But I'm sure that you will do it.
Already sort of perhaps tested your patience more than.
No, not at all. Which?
Mulats, this page, first paragraph.
Which page?
Page 1, Mulats. PDF page 2. This is a Constitutional Bench judgment. Lakhan Pal versus State of Jammu and Kashmir. I won't deal with the reorganization, Mulats. There'll be other senior counsel will deal with it, but I'll broadly tell your lordships what the summation is. And then they can deal with it more elaborately. The application of a writ of habeas corpus is directed against the state of Jammu and Kashmir, which has by its order dated 4/10/1955 directed the detention of the petitioner under Section 3 of the Jammu and Kashmir Preventive Detention Act, hereinafter referred to as the Act. Originally, the sole respondent impleaded was the state of Jammu and Kashmir. After the Rule Naisa was issued to the respondent, the Union of India intervened because the petitioner had challenged the validity of the constitutional application of the Jammu and Kashmir Order 1954. Those are the facts, and the order is set out, Mulats, as PDF 4.
6.
PDF 4. Yes, I'm just reading the order. Yeah, that's the order. Whereas the government are satisfied that Lakhan Pal, chairman so-and-so, has a view to preventing him from acting in a manner prejudicial, it's necessary to make the order, and therefore they make the order. Then kindly come to paragraph 4. This order was to remain in force, Mulats, for 5 years. But it was extended. The petitioner contended that you can't extend this order. That's how the matter came up. So your lordships will find in paragraph 4 Act impugned in this case provides that it shall remain in force for a period of 5 years. Relevant portion is that, so let's skip that, Mullahs. Then kindly come to paragraph 6. In the quoted portion, Mullahs, in paragraph 6, PDF 6. No law with respect to preventive detention made by the legislature of the state, whether before or after the commencement of the constitutional application to Jammu Kashmir Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the order, except as respects things done or omitted to be done. The effect of the modification in 35 is that such of the provisions of the Act are as consistent with Part 3 of the Constitution, shall be valid until the expiration of 5 years from the commencement. This is an exception which has been engrafted on the Constitution in respect of fundamental rights relating to personal liberty for a period of 5 years. The Act itself has a limited life of 5 years, thus exception aforesaid is coextensive with the life of the Act itself. Hence, so long as the Act continues in force in its present form, the provisions of Articles 21, 22, insofar as they are inconsistent with the Act, are out of the way of the respondent, and the petitioner cannot take advantage of those provisions. Therefore, there is no question of the provisions of Section 8 of the Act being unconstitutional, by reason of their being inconsistent with 21 and 22. Then paragraph 8. Mullahs, he realized, the petitioner realizing the difficulty, Mullahs. Realizing the difficulty in the petitioner's way in view of the provisions of clause C added to Article 35, the learned counsel for the petitioner faintly suggested that clause C of 35 added by the presidential order was itself bad, as so the argument further ran that provision was in excess of the powers conferred by the president on the president by 370. No attempt was made on behalf of the petitioner to show how the order promulgated by the president was in excess of the powers of 370. It was not contended that the article did not authorize the president to promulgate the order. What was suggested was that the promulgating the order, which the president was authorized to make under 370, had exceeded his powers. This argument was ultimately rejected. So the detention was upheld. Then, Mullahs, the next judgment is Premnath Kaul. This relates to land. Right.
लखनपाल में कुछ खास नहीं है.
And Mullahs, paragraph, this is also a constitutional bench judgment. That's Mullahs PDF 8. A suit was filed by the appellant in a representative.
Lakhanpal, nothing really turns much, I think.
No, nothing much. That's right. But then those provisions were extended, Mullahs, from time to time. This particular issue came up, Mullahs, kindly see, this is important, page 8. PDF page 9. Paragraph 6. 6 and 7. What happened was, Mullahs, in dealing with this appeal, it's necessary to relate some detail the events that took place in Kashmir and the constitutional changes which followed them in order to appreciate fully the background. A clear understanding of this background will help us deal with the appellant's case in its proper perspective. In 25, Hari Singh succeeded Pratap Singh as the ruler. It appears that for some time prior to 34, there was public agitation in Kashmir for establishment of responsible government. Presumably, as a sequel to the said agitation, Hari Singh issued Regulation 1 of 91. The regulation began with a statement of policy that it had the declared intention of the Maharaja to provide for the association of his subjects in the matter of legislation and the administration of the state, and that it was in pursuance of the said intention that the regulation was being promulgated. Regulation consisted of 46 sections, which dealt with the legislative, executive, and judicial powers of the Maharaja, referred to the subjects which had to be reserved for the operation of regulation, made provision for the constitution of the legislature of a state, conferred authority on the council to make rules for specified purposes. It is relevant to refer to only two sections of this regulation. Section 3 provides that all powers, legislative, executive, and judicial, in relation to the state and its government are hereby declared to be and to have been always inherent and possessed and retained by His Highness, the Maharaja of Jammu and Kashmir, and nothing contained in the regulation shall affect or deem to affect the right of the prerogative of His Highness to make and pass regulations. These regulations, passing of these regulations was challenged, and ultimately the court held, but this power is retained by the Maharaja. So therefore, you can't really challenge them, despite the fact that we are in the year 1959. So those powers continued, and ultimately, the court upheld them. Kindly see para 12 at PDF 10. Meanwhile, the invasion of the state had created tremendous popular fervor and patriotic feelings in resisting the act of aggression, and this popular feeling inevitably tended to exercise pressure on the Maharaja for introducing responsible and popular government. Maharaja tried to pacify the popular demand by issuing a proclamation on March 8, 1948. By this proclamation, he stated that in accordance with the traditions of his dynasty, he had from time to time provided for increasing association of his people with the administration of the state, with the object of realizing the goal of full responsible government at as early a stage as possible. And he added that he had noted with gratification and pride the progress made so far and the legitimate desire of his people for the immediate establishment of fully democratic constitution based on adult franchise, with a hereditary ruler from his dynasty as the constitutional head of an executive responsible to the legislature. Remember, by this time, the 1957 Constitution of Jammu and Kashmir had come into play. So the argument was, how do you expect this Maharaja to continue with the power when we have a constitution of our own? So therefore, this power and this proclamation issued by him is bad. It's in that context that the judgment is rendered. It appears that before this proclamation was issued, the Maharaja had already appointed Sheikh Muhammad Abdullah, who was then the popular leader of the people, at the head of the emergency administration. By the proclamation, the Maharaja replaced the emergency administration by popular interim government and provided for its powers, duties, and functions pending the formation of fully democratic government. Clause 1 of proclamation provides for the composition of the ministry. You lordships may leave that, Malas. I straight away come to para 23. PDF page 14, paragraph 23. This was the contention of in the suit, which ultimately came to the Supreme Court. The validity of the act is impeached mainly on the ground that Yuvraj Karan Singh had no authority to promulgate the said act. It is this argument which has been urged before us by Mr. Chatterjee in different and alternative forms needs careful examination. The first attack against the competence of Yuvraj proceeds on the assumption that at the time when the Maharaja Hari Singh conveyed his powers to Yuvraj by his proclamation in 49, he was himself no more than a constitutional monarch, and as such he could convey to Yuvraj Karan Singh no higher powers. Let us first deal with this argument. Prior to the passing of the Independence Act, the sovereignty of Maharaja Hari Singh over the state of Jammu and Kashmir was subject to such limitations as were constitutionally imposed on it by the paramountcy of the British Crown and by the treaties and agreements entered into between the rulers of the state and the British government. It cannot be disputed that so far as the internal administration and governance of the state were concerned, Maharaja Hari Singh, like his predecessors, was an absolute monarch, and that all the powers, legislative, executive, and judicial, in relation to his state and its governance inherently vested in him. The position has been emphatically brought out by Section 3 of the regulation, though by this regulation, Hari Singh gave effect to his intention to provide the association of his subjects in the matter of legislation and administration. By Section 3, he fully preserved to himself all the existing legislative, executive, and judicial powers. Section 3 not only preserves the said powers, but expressly provides that nothing contained in the regulation shall affect or deem to have affected the right and prerogative of His Highness. But as your lordships may leave this now, and then it is, however, urged that the constitutional position, substantially altered by the subsequent Constitutional Act of 1996, we are unable to accept this argument. 4 and 5 of this Act in terms continue to preserve the powers, legislative, executive, and judicial, as well as the right and prerogative of His Highness, just as Section 3 of the regulation of 1991. So, but they uphold it, even though there is a Praja Sabha at that time. They said the Maharaja's powers are intact. But of course, the situation is completely changed now. You no longer have the Maharaja. So now all the powers are with the legislature. So in a sense, this is a it's a pre-1957 situation, which preserved the powers of the Maharaja till the Maharaja had to give up his powers. So let's not. That's all right. And let's quickly now. Now, kindly see 34, just 1 minute. 34, PDF 19. Having provided for the legislative power of Parliament and for the application of the articles of the Constitution, Article 370, Clause 2 prescribes that if the concurrence of the government of the state required by the relevant sub-clauses of Clause 1 has been given before the Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly for such decision as it may take thereon. This is what I was saying in the morning as well. Even in respect of laws passed, the concurrence of the Constituent Assembly was necessary. This clause shows that the Constitution makers attach great importance to the final decision of the Constituent Assembly, and the continuance of the exercise of powers conferred on Parliament and the President by the relevant temporary provisions of 371 is made conditional on the final approval by the said Constituent Assembly in such matters. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions and modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendation in that behalf. This is also a Constitution Bench judgment.
Which para is this, Mr. Sibil?
This is para 35.
What's the year of the judgment?
1959. Sorry, I'm sorry. Give the year, please. 59. After the Constitution of Jammu and Kashmir come to. And this is a Constitution Bench judgment. Clause 3 authorizes the President to declare by public notification that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by the President only if the Constituent Assembly of the state makes recommendations on that behalf. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to the relevant matters covered by 370. This is how this court also understood it. The appellant contends that the scheme of this article clearly shows that the person who would be recognized by the President as the Maharaja of Jammu and Kashmir was treated as no more than a constitutional ruler of the state. In regard to matters covered by this article, he could not function or decide by himself and his own discretion. The Constitution contemplated by this article had to be with the Maharaja acting on the advice of the Council of Ministers, and the concurrence prescribed by it had to be similarly obtained and given. And that brings out the limitations of the powers of the Maharaja. It is also urged that the final decision in these matters had been deliberately left to the Constituent Assembly, which was going to be convened for the framing of the Constitution of the state, and that again emphasizes the limitations imposed. This argument assumes that under Article 370, sub-Article 1, it is the person recognized by the President as the Maharaja who has to act on the advice of the Council of Ministers in relation to matters covered by 370. But it is possible to take the view that the said clause really indicates that in recognizing any person as the Maharaja of the state, the President has to act on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation dated 5th March 1948. If that be the true construction of the explanation, then the argument that before the Maharaja is consulted or its concurrence is obtained, he must act on the advice of the ministers would not be valid. We would, however, like to deal with the argument, even on the assumption that the construction put by the appellant, the explanation is right, and then they deal with it. On the said construction, the question which falls for consideration is, do the provisions of 370 affect the plenary powers of the Maharaja in the matter of governance of the state? The effect of the application of the present article has to be judged in the light of its objects and its terms considered in the context of special features of the constitutional relationship between state and India. The constitution makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself. mark these words please, that it is the main basis and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to its subject matter. It would not be permissible or legitimate to hold that by implication the article sought to impose limitations on the plenary legislative powers of the Maharaja. These powers had been recognized and specifically provided by the Constitution Act of the state itself, and it was not and could not have been within the contemplation or competence of the constitutional makers to impinge even indirectly on the said powers. It should be recalled that the instrument of accession, those powers have been expressly recognized and preserved, and neither the subsequent proclamation issued by Ruvraj, adopting as far as it was applicable the proposed Constitution of India, nor the Constitution order subsequently issued by the President, purported to impose any limitations on the said legislative power. What form of government the state would adopt was a matter which had to be and naturally was left to be decided by the Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by the instrument of accession. It would therefore be unreasonable to assume that in the application of 370 could have affected or was intended to affect the plenary power. So, Maharaj, this is how this court, Constitution Bench of this court, interpreted 370. And then, Maharaj, they refer to 245, 254 and say that those provisions were not applicable anyway. Then it says, it is difficult to see how this article supports the appellant's contention. In fact, it is not easy to appreciate what the application of this article to the state meant. As we've already pointed out, the application of the specified articles to the state was not intended to affect and constitutionally could not have affected the form of government prevailing in the state and the plenary legislative powers of the Maharaja. And that was all this was, the rest is. So that gives you an indication as to how a constitutional bench of this court looked at 370. And in the context of the Constituent Assembly, leaving it to the Constituent Assembly to decide upon the relationship between the state and the Union of India at that point in time. The next is Maharaj Lakhanpal Samamas. This is not necessary. This is the second Lakhanpal Maharaj, where Maharaj again he challenges detention. And the law on detention was extended to 15 years. And therefore that detention was also upheld. So we'll skip Maharaj the second Lakhanpal. Yes. Yes, sorry. No, it's not detention. It's the second one, Sampath Prakash, that's detention. This is a case, Maharaj, where members were sent at the instance of the legislature to Parliament on a recommendation of the legislature, which was a special provision in 81 of the Jammu Kashmir Constitution, and said that, look, there can be no direct election. It has to be at the three of them. A few of them have to be at the instance of the legislature, on the recommendation of the legislature. Really speaking, the core issue is it's all right. Let's not go into it. Sampath Kumar was this. Yeah. This was a case of detention, again a case of detention. And kindly come to paragraph. And the law of detention was extended from time to time till it was for 15 years at a stretch. And that detention order was challenged. But see that PDF 29, paragraph starting the first argument. Yes. Continuation of paragraph 4 at PDF 28. He challenged his detention order, and the first argument he made was the following. PDF 29, what's the time? Finish. My lord has that?
They say that the power of the president to make modifications is of the widest amplitude.
That's Lakhanpal.
That's Lakhanpal.
Yeah. Lakhanpal 2, right?
And that the power to make a modification includes the power to make an amendment to the constitution.
Yes, yes. And that is also with the concurrence, Malaj. It's not without concurrence. That's not without concurrence, Malaj.
Yes, that's right. That concurrence was not an issue there.
Just saying, Malaj. It's not in the absence of concurrence. It's
Obviously.
But 368 is therefore not really applicable as well. Because you're not amending the main constitution.
That's right. That's right. Absolutely right. Doubtable. Doubtable. Now, Malaj, now in this Sampath Prakash, PDF Malaj 29, and I'm inviting my lords to paragraph 4 at PDF 28 at 29, the PDF 29, the first argument. The first argument, no, my lord has that. The first argument was that this article contained temporary provisions which ceased to be effected after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir had completed its task by framing the Constitution of that state. Reliance was placed on the historical background in which Article 370 was included in the Constitution to urge that the powers under the article were intended to be conferred only for the limited period under the Constitution of the state was framed, and that the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background of the legislative history to which reference was made was brought to our notice by learned counsel by drawing attention to the speech of Gopalaswamy Iyengar, which your lordship read, when he moved in the Constituent Assembly clause 306A of the bill, which now corresponds to 370. It was stated by him, the condition that leave that out, Mullah. Then, further down, Mullah, after those 7 items, learned counsel urged that in this background, 370 of the Constitution could only have been intended to remain effective until the Constitution of the state was framed and the will of the people of Jammu and Kashmir had expressed. And thereafter, this article must be held to have become ineffective. So that the modifications made by the President in exercise of the powers under this article, subsequent to the enforcement of the Constitution of the state, would be without any authority of law. The Constitution of the state came into force on 26 January 56, and therefore the 2 orders, 59 and 64, passed by the President in perpetuate exercise of power under 370 were void. It was also urged that the provisions of Clause 2 of Article 370 support this view. It would also urge that the provision support this view because it directs that if the concurrence of the government of the state is given under Para 2 of Subclause B of Clause 1, or under the second proviso to Subclause D of that clause before the Constituent Assembly for the purpose of framing the Constitution of the state is convened, that concurrence had to be placed before such assembly for such decision as it may take thereon. From this, it was sought to be inferred that the power of the President, depending on the concurrence of the government of the state, must be exercised before the dissolution of the Constituent Assembly of the state, so that the concurrence could be placed for its decision, and that power must be held to cease to exist after the dissolution of the Assembly. Were not impressed with either of these 2 arguments advanced by Ramamurthy. So far as the historical background is concerned, the Attorney General appearing on behalf of government relied on it to urge that the provisions of 370 should be held to be continuing in force. This is important. Continuing in force because the situation that existed when this article was incorporated in the Constitution had not materially altered, and the purpose of introducing this article was to empower the President to exercise his discretion in applying the Indian Constitution, while that situation remained unchanged. There is considerable force in this submission. The legislative history of this article cannot in these circumstances be of any assistance for holding that the article became ineffective after the Constituent Assembly of the state had framed the Constitution. And then, Mullahs, ultimately, para 7 is important. There are, however, much stronger reasons for holding that the provisions of this article continued in force and remain effective even after the Constituent Assembly of the state passed the Constitution of the state. The most important provision in this connection, kindly note that, is contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues a notification. Well, that's what I was trying to tell my Lord Justice Khanna. Before, this is a Constitution bench judgment. This clause clearly envisages that the article will continue to be operative and cease to be operative only if, on the recommendation of the Constituent Assembly, the President will make a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the presiding President declaring that the article shall cease to be operative. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative, with one modification to be incorporated in the explanation of clause 1 of this article. This modification in the article was notified by the President by the Ministry of Law, CO 44 dated 15 November 52, and laid down that the 17th November 52, the article was to be operative with substitution of the new explanation for the old explanation as it existed at that time. This makes it clear that the Constituent Assembly of the state did not desire this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article for making a recommendation that it should preserve.
That's 1 minute.
Yeah. The next submission made for challenging the validity of the orders of modification made in 59 and 64 was that subclause D of clause 1 of 370, the power that is conferred on the President is for the purpose of applying the provisions of the Constitution to Jammu and Kashmir, and not for the purpose of making amendments in the Constitution as applied to that state. The interpretation sought to be placed was that at the time of applying any provision of the Constitution to the state of Jammu and Kashmir, President is competent to make modifications and exceptions therein. But once any provision of the Constitution has been applied, the power under 370 would not cover any modification in the Constitution as applied. Reliance was thus placed on the nature of the power conferred on the President to urge that the President could not, from time to time, amend any of the provisions of the Constitution as applied to the state of Jammu and Kashmir. It was further urged that the presidential power under 370 should not be interpreted as applying Section 21 of the General Clauses Act, because the constitutional power cannot be equated with the power conferred by the Act. Whereas the court ultimately relied on 21. The argument in our opinion proceeds on an entirely incorrect basis. Under 371D, the power of the President is expressed by laying down the provisions of the Constitution other than Article 1 of 370, which under 371C became applicable when the Constitution came into force, shall apply in relation to the state of Jammu and Kashmir, subject to the exceptions and modifications that the President may order specified. What the President is required to do is to specify the provisions of the Constitution which are to apply to the state of Jammu and Kashmir. And when making such specification, he is also empowered to specify exceptions and modifications to those provisions. As soon as the President makes such a specification, provisions become applicable to the state with the specified exceptions and modifications. The specification by the President has to be in consultation with the government of the state if those provisions relate to matters in the union list and the concurrent list specified in the instrument of accession, governing the accession of the state to the Dominion of India, as matters with respect to which Dominion legislature will make law. The specification in respect to all other provisions, that is subclause D, clause 1 of 370, has to be with the concurrence of the state government. Any specification made after such consultation or concurrence has the effect that the provisions of the Constitution specified with exceptions and modifications become applicable to the state of Jammu and Kashmir. Cannot be held that the nature of the power contained in this provision is such that Section 21 must be held to be totally inapplicable. So, that's it, Malad, as far as. No, Malad. Para 14, sorry. It was also urged, para 14, PDF, Malad, 33. It was also urged that the power of making modifications and exceptions in the orders made by Article 371D should at least be limited to making minor alterations, not cover the power to practically abrogate an article of the Constitution applied. That submission is clearly without force. Challenge to the validity of 35C introduced to the Constitution as applied to Jammu and Kashmir on this ground was upheld by the court in Dakhanpal. Subsequently, the scope of the powers of making exceptions and modifications was examined. So, Malad, as long as the exceptions or modifications are made with consultation or concurrence, depending on the instrument of accession or the concurrent list matters, Malad, there's no issue at all. The President could do it. But beyond that, no. Malad, now, therefore, now this is the case that the other side is relying upon, that was C67. This is the important case. That is PDF 36, same volume. Makbul Daman. It's a 32 petition. Again, a detention matter. What's the time? Yes, then I'll finish. After this, I'll touch for 5-10 minutes on the Reorganization Act. The rest others will do this. I have done. Well, let's, Mr. Garg, but this is again a detention matter, who appeared on behalf of the petitioner, raised the following points. Paragraph 6 at page 40. Very inspirational lawyer, Mr. Garg was. Yeah. He would be sitting at the back of this court and pretend to be sleeping when he would suddenly wake up. He'd suddenly wake everybody up, including himself. And he'll tell the court that they were wrong or they were right. An amazing personality. And wedded to the cause of at least in matters of preventive detention, and always appearing for the weak and for the marginalized, always. We owe him a lot. Mr. Garg, who appeared on behalf of the petitioner, raised the following points before us. That the Jammu Kashmir preventive detention, herein referred to as the Amending Act, was invalid as it was assented to by the Sadr-e-Riyasat. Not invalid, as was not assented to by the Sadr-e-Riyasat. It was assented to by the governor, but he said the Sadr-e-Riyasat was directly elected. The governor was not directly elected, so therefore this is completely unconstitutional because he did not give his assent to it. That the proviso inserted by 4.2 of Section 8 is bad because it suffers from excessive delegation. There has been no violation of Article 21(22). At any rate, the proviso is bad because it conflicts with Section 103 of the Constitution. The detention order is bad because the detaining authority has not applied its mind, and the order of detention is bad because it's not served or executed in accordance with law. In support of his contention, learned counsel urged that 370 was the only authority which is recognized as the government of the state of Jammu Kashmir is the Sadr Riyasat. 370 contemplates that Sadr Riyasat would be the head of the state of Jammu Kashmir, and Jammu Kashmir Assembly had no power to abolish the office of Sadr Riyasat. He further urged that Section 147 of the Constitution, which I've read to your Lordship, also contemplates that the Sadr Riyasat shall exist and be the head of state. He urged that the only possible way of getting rid of the Sadr Riyasat would be to amend the Constitution of India as applied to Jammu Kashmir. Learned Attorney General who appeared on behalf of the government, Mr. Chagla, who appeared for the state, contended that the Constitution of Jammu Kashmir, which had received the assent of the Sadr Riyasat, validly amended the Constitution of Jammu Kashmir and validly provided for appointment of a governor in place of Sadr Riyasat, and therefore the governor was competent to give assent to the Jammu Kashmir preventive detention. That was the limited issue, that the Sadr Riyasat was directly elected, governor was appointed, the Sadr Riyasat never gave his consent, therefore this detention law where the governor gave consent is bad. Then straight away, 13 minutes. Paragraph 13 at PDF 42. On January 26, 1950, the constitutional application to Jammu Kashmir Order 1950 was made by the President. On April 20, 1951, the Maharaja of Jammu Kashmir issued a proclamation in pursuance of which the Constituent Assembly of Jammu Kashmir was convened on November 5, 51. On June 10, 1952, the principals of the Committee of Jammu Kashmir's Constituent Assembly submitted an interim report in para 14. The Constituent Assembly by a resolution adopted these recommendations. The following part of the resolution is relevant. Now, therefore, in pursuance of the resolution dated 12 June 52, and having considered the report of the drafting committee, this assembly resolved that the head of the state shall be the person recognized by the President of Union on the recommendations of the Legislative Assembly. Later on, Mullah, it was directly appointed. Sorry? Oh, I see. I'm sorry. The head of state shall be the person. He shall hold office during the pleasure of the President. He may, by writing under his hand, address to the President, resign his office. Subject to the foregoing provisions, the head of state shall hold office for a term of 5 years from the date he enters upon his office. And then, Mullahs, provided that he shall, notwithstanding the expiration of his term, continue to hold office until his successor enters, that the recommendation of the Legislative Assembly of the state in respect of recognition of the head of state shall be made by election. Then, Mullahs, November 16, 1952, the explanation was, Mullahs, in a way, it was amended by a recommendation of the Constituent Assembly. Just mark that, Mullahs. In exercise of the powers conferred by this article, the President, on the recommendation of the Constituent Assembly of the state, declared that as from 17th day of November, the said 370 shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted. For the purpose of this article, the government of the state means the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as the Sadr Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers. So when this argument was raised, the court ultimately came to the conclusion that in essence, this Sadr Riyasat is a governor. So there is no substantial change. Then go, let's directly to 19, Mullahs. PDF page 44. I'm trying to, Mullahs, hasten the pace so that. On November 1756, Jammu and Kashmir Constitution was adopted. Some sections came into force on the day of and remaining sections came into force in 57. Then there's few lines thereafter on November 24, 65. This is important. The President, in exercise of the powers by clause 1 of Article 370, with the concurrence of the government of Jammu and Kashmir, made the Constitution application to Jammu Kashmir's Second Amendment Order 1965 for subclause B of clause 4 of 367. Lordship sees that? The following clauses were inserted. References to the person for the time being in force recognized by the President on the recommendation of Legislative Assembly as the Sadr Riyasat, acting on the advice of the Council of Ministers of the State for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And references to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. Then para 21, according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at that time. What are the constitutional conditions? Well, every state had a governor. He was not directly elected. And Constitution of Jammu and Kashmir itself stood amended in 1965, Malas. And the head of the state was to be the governor. So according to the Attorney General, this is a mere definition inserted for the purpose of the article in accordance with the constitutional conditions prevailing at the time. According to Mr. Garg, this is the kingpin of the whole relationship between the Union of India and the state of Jammu and Kashmir. According to him, neither the Jammu and Kashmir Assembly nor the President were competent to impair the functioning of the Sadr Riyasat insofar as the Constitution of Jammu and Kashmir, Sixth Amendment Act 1965, replaced the Sadr Riyasat by the governor is ultra-virus. According to him, either there has to be an amendment to the Constitution of India under 368 and 373, or a fresh Constituent Assembly had to be convened to amend the explanation. He said that if the text of the Constitution is explicit, effect must be given to it, and it is not the duty of the courts to improve upon the Constitution because the Constitution makers had not anticipated it. So, the court rejects that argument. And then, at page 24, this para 24 is the heart of the matter. The Learned Counsel, relying on Sampath Prakash, contended that the only way of modifying 370 is specified in Article 370, sub-Article 3 itself. He said that this was expressly laid down by this court in the decisions referred to. We are not concerned with the question whether Article 373 can now be utilized to amend the provisions of 371 or 2, and therefore, we do not express any opinion on that point. We are now not concerned with an amendment to Article 370, subclause 1. We are concerned with a situation where the explanation ceased to operate. It has ceased to operate because there is no longer a Sadr Riyasat in Jammu and Kashmir. Now, next is important. If the definition contained in the explanation cannot apply to the words government of the state, since the meaning of Article 367(4) is amended, will have to be given to it. It is this meaning, if this meaning is given, it is quite clear that the governor is competent to give the concurrence stipulated in Article 370. And then, Malats, kindly come straight away to para 29.
Para?
PDF page 47. I had Malats, your PDF page 47. If we had regarded this as an amendment to Article 370, Clause 1, then we would have had to consider whether the amendatory powers had been validly exercised or not. But as we have said, we're not concerned with that question.
Which para is this?
This is 29.
29.
Yes. So clearly, Malas, Damnu is not for a proposition that you can amend 370 in this process by virtue of 367(4). That's what the union has tried to apply. That Damnu has already decided this issue. So, Mullahs, now I am finished with the judgments also. Now I'm left with the last, which I'll finish by 4 o'clock. 15 more minutes.
That's the reorganization.
That's the Reorganization Act. Now, Mullahs, let's go to the, first of all, So Jammu and Kashmir, Constitution of India as applicable to Jammu and Kashmir, Article 3. This is Mullahs at document volume 2, PDF page, 1, not 2. PDF page 65. Article 3, Mullahs. Proviso, we don't talk about union territory. So I've shown you what's the proviso already in Article 3, Malas, that no bill shall be introduced in Parliament without the consent of the legislature of the state. And I shown to your lordship the August 5, Malas, the bill was introduced. Now see the Constitution of India along with this, Article 3 of the Constitution. I'll just make a brief argument so that Malas, then others can, if they so choose, which they will, I'm sure.
Article 3, right?
Constitution of India, Article 3. Formation of new states and alteration of areas, boundaries, or names of the existing states. Parliament may by law, my lords have that, may by law form a new state by separation of territory from any state. So if you have a large state, you can form a new state by separation of territory of any state, or by uniting two or more states. So you can form a new state by uniting two or more states, or parts of states, or by uniting any territory to a part of any state. That's the way you form states, Malas, or you bifurcate states. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Provided that no bill for the purpose shall be introduced to either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred to by the President to the legislature of that state for expressing its views thereon, within such period as may be specified in the reference, or within such period as the President may allow. The period so specified or allowed has expired. Explanation. This is important. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. The power, then explanation 2, the power conferred on Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Normally, if you're going to read in explanation 1, state includes a union territory. Let's go back to the definition now. Let's see how it fits in. So now you say form a new union territory. Let's read the word instead of state as union territory. If you, Malads, substitute the word union territory wherever the word state is used, this article will make no sense. And I'll read it in that fashion. Form a new union territory by separation of territory from any union territory.
No, but it could be for by separation of territory from any state.
That's correct. So therefore you can't read, therefore only in the first part you will read union territory. That's my submission. In other words, form a union territory by separation of territory from any state. You can do that. Or by uniting two or more states, you can have a union territory. Or parts of states, you can have a union territory. Or by uniting any territory to a part of any state. How can you create a union territory for Jammu and Kashmir under this article? You can't do it. You can carve out a union territory. You can't create a union territory under Article 3 and convert it into a state into a union territory. That's contrary to all principles of representative form of government. It doesn't allow extinguishment of a state completely. Can you say that tomorrow Madhya Pradesh will be a union territory or Bihar will be a union territory? You can do it to one, you can do it to all. You can have a presidential form of government, create all states, convert all states into union territory. By what stretch of imagination
But
can
what
you?
about textually?
I'm sorry?
Textually. The other argument is, of course, that you can't do it because you said representative democracy, but textually can you not do it?
No, because I'm saying you form a union territory by separation of a territory from a state. From any state. Or by uniting two or more states or parts of a state. This is not that exercise at all. You have created two union territories from a state. Where is that power? Well, there are multiple categories. What they've done doesn't fall in any of these categories. You can carve out a union territory. If you have two or more states come together, you can carve out a union territory. If a part of a state, you can carve out a union territory. But you can't create two union territories in a state. How is that possible? Apart from what my lord said, representative form of government, you can't. You're not going back, Madas. Moving away from a representative form of government. This is not a reverse. Yes, yes, that was possible. Whereas you could have kept Ladakh, Madas, as a union. I'm sorry.
Parameter. The report is there on record.
I won't go into it, my colleagues will, which tells you as to how the union thought as to how union territories are to be created. In 1953, way back, there's a State Reorganization Commission. My learned friends will refer to it. I don't want to, let's do that. But essentially, there are two aspects to this. The text of the Constitution doesn't allow you to do that. And the fundamentals of constitutional democracy don't allow you to do that. You can't go back in time, move from representative.
My judgment in NCT 2 traces the history of how you had the Part A, Part B, Part C state. How then, after the 7th Amendment, you replaced the Part B and Part C states and the union territories were created.
And NCT judgment deals with asymmetric federalism. It's a case of asymmetric federalism. Of course, now they've done something else, so that your lordship is here now. Another way. Otherwise, Madas, this power can be exercised at any time. Yes. Yeah. Words, Malad. Where is the voice of the people of Jammu and Kashmir? Where is the voice of representative democracy? 5 years have passed. Have you heard, Malad? Any representative form of government? When you convert a whole state, Malad, this way the whole, all of India can be converted. This power is given. And Malad, the proviso said you have to take the consent. You do away with that through an executive act. You don't even take their views. You become the legislature yourself. So where do we stand, Malad? We stand at a situation where, Malad, though the Constitution is a political document, its provisions can't be manipulated and maneuvered for political ends. It cannot be. That's not how you interpret a constitution. It is a political document, but you cannot politically misuse it and maneuver it and manipulate it, which is what has been done. That can't be done. And even when there is a clash of arms, the law is never silent. The law is not concerned with that. The court is never silent. And whenever the court has been silent, the consequences have been disastrous. It's time for your lordships. And what is a constitution? A constitution is a set of values. Values on the basis of which people will represent themselves and their voice will be heard. If you, through such executive acts, silence the voice of the people, what is left of democracy? And all that I can say to your lordships is that this is a historic moment. Historic not for the present, but for the future of India. And I hope this court is not silent. Thank you.
Thank you very much,
Only
Mr.
one-
Subba. Thank you.
Only one
Who
thing.
will follow now?
What was, just my lord, since this occurred, my lord, on the union territory part, the lordship would also examine, my lord, after the court is over.
Yes.
What was read was the provisions of Article 3 as applicable to Jammu and Kashmir then. Thereafter, the entire constitution is applied before the reorganization took
Yes,
place.
yes, that's what
And
we are
therefore,
challenging.
please read as applicable to entire country.
I read
Your
both.
lordship would get the answer.
I read both,
Was a
both
little
applicable
bit-
as well as the constitution. My religion is wrong. I read both. I was reading the Constitution Article
The
3.
explanation
Both.
was not written. Kindly
No,
have
you're- what are you saying?
Puzzle.
I don't know. Obviously, you didn't even hear what I said. So therefore, he was silent where I was arguing, Manoj.
I can't interrupt him.
Mr. Zafar Shah will be arguing now.
Lord, I beg to appear, my lord, after Mr. Sibal.
All right. Mr. Subramaniam, which area would you be covering broadly?
My lord, I will be covering some parts of the unfinished, if I may say so, portions of Mr. Sibal. Largely, I wouldn't take very long. Your lordships may be assured of that. But there are some points, my lord, which need to be cemented, particularly with reference to the decision of the Constituent Assembly of Jammu and Kashmir itself.
So we begin tomorrow morning, Mr. Subramaniam. Can we request you to complete by lunch tomorrow?
I think, my lord, that's a very fair suggestion.
After that, who will be the next person in line?
So, yes, certainly. Then we will hear, so Mr. Subramaniam will take through to lunch tomorrow, and then you can, how long would you take? Okay, by the end of the day tomorrow.
और होगा